And I'm just thinking, when I was looking around, I wasn't looking to my right, the prosecution. I had seen, however, that you were present. Mr. Van Eyck. Members of the bench, members of the prosecution, counsel for the relatives, ladies and gentlemen. I shall be continuing with the section on evidentiary question 3, actual behavior. I'll see whether I can cover everything in one go, and should it take a bit longer, well, we'll have to wait and see what we do with the breaks. It is a clear section. No problem, says the judge. I think I can cover everything, says counsel. That is, if I don't sidestep from my text, we know more or less how much time I will need. Right, so chapter 1.13, title being Change in Chain of Command. And I have handed over a separate table of contents with a number of annexes, which are the intercepted calls that had been made available. And so that document is added to the pleading notes. I'll be commenting on that later on. Last Friday, I discussed the duties of Pulatov and his position in the chain of command. What is striking in this respect is that the evidentiary sources only consist of telephone conversations and not witness statements, whereas in a subject such as participation, statements can give more clarity in terms of the actual course of events. And also, if you look at other case files, you see more statements under the title participation in order to clarify matters. And that is something that we do not have in this case. When we only interpret telephone conversations, we only base our views on appearances without actually discussing the inner core of the actual situation. And this subject, changing chain of command, here that is a situation that applies, albeit that here we do have our client's statement. And before I discuss that, I shall first point out what we can read and see in the intercepted conversations. Let me start with the conversation held on 17 July at 10:01 in the morning between Gherkin, who is referred to in the intercept report as Pervy, and Averianov being Thor. The latter, in this conversation, asks for explanation on the hierarchy. And the question is, who is the oldest here? And he says, is it Kep or is it Djurza? The answer is, for the time being, Kep is responsible for defense, and Djurza and his men are placed in reserve. But for the time being, since he's not left yet, he will be performing the position of oldest or eldest. Later on in the conversation, they discussed that artillery needs to be deployed, not anti-aircraft, but artillery against the enemy in the hills, because they're firing from the hills, presumably. And then Gherkin says, I have given all instructions to Djurza. The prosecution once again reads into this conversation that Djurza without I equals Pulatov. Well, insofar as the court would accept this, it's relevant that the prosecution, in this part of the prosecution's address, included a subchapter entitled Gherkin gave Pulatov instructions. This subchapter is part of the greater chapter Organization of Transport and Transporting and Guarding the Booktailer. And this is not the first time in the prosecution's address, but here the prosecution suggests and implies that with the words instructions from Gherkin to Pulatov, that Pulatov would have received instructions from Gherkin about guarding the book teller, and this in the conversation of 1 minute past 10. Nothing could be further from the truth, because from the conversation we can clearly infer that this concerns instructions about artillery fire. There is no mention in this conversation whatsoever about anti-aircraft defense. At the end of the prosecution's address, the prosecution says in this connection, we do not know exactly which instructions Gherkin gave in the morning of 17 July 2014. Well, members of the bench, if that, according to the prosecution, is not known, what kind of instructions were given, it's simply not appropriate to speculate about it. Nor is it appropriate to build an evidentiary structure on that basis that would lead to lifelong imprisonment. The prosecution also has a responsibility vis-à-vis the defendants. This is not my pleading notes, and that responsibility means that you need to be cautious when using suggestion, speculation, if you yourself say that you do not know exactly what those instructions entailed. And this sense of responsibility is lacking here. The prosecution establishes a link with a conversation of 9:55 a.m. So this is just before the 10:01 conversation. This is a conversation between Dubinsky and Pulatov. And this conversation is not relevant either, because in this conversation they speak about Pervy. Pervy would stand for Gherkin, that there's just been a conversation with Pervy, Gherkin, but this seems to be in connection with the fact that Cap is now around and nearby, and that he needs to be told that the 3 tanks mentioned in that conversation they refer to rhinos, but those tanks have arrived. Those tanks are relevant in the light of Gherkin's instructions concerning artillery fire that are just mentioned. The earlier telephone conversation between Pulatov and Pervy was again about that, which is why it is suggestive and incorrect to place this conversation in the prosecution's address under the chapter guarding and transporting the book. The conversation was not about that, and someone who simply listens to the public prosecution's address may think as much should they not study the facts in detail. Let me return to the changes in the chain of command. In the evening of 16 July 2014, a change in the chain of command had already been discussed, and this follows, amongst others, from the conversation at 18:12 p.m. that evening on 16 July 2014, a conversation between Dubinsky and Pulatov in which we hear several times that Kep will arrive on 17 July 2014, and then all our units will then withdraw, and what they refer to is Pulatov's unit. As I said, Kep indeed arrives on 17 July, as they expected on 16 July. And at 20:49 hours p.m., 16 July, Dubinsky confirms as much. He says that when Kep's men arrive, Pulatov will transfer the entire command to him. And that is precisely what happened the next day from 10:01 onwards. And this is also completely in line with what Pulatov himself said in his statement. He said, yes, as I said, it was a busy day, and he's referring to the 17th. The day was mainly determined by the meeting that I had at 10 a.m. at the commander's surveillance post near Schnitznoi. There were a number of commanders present at that meeting, and we discussed a whole number of matters, such as the supply of hot food, catering, humanitarian issues, a number of command issues, and also a decision was made with respect to the change in the chain of command and moving forces. So the matters that were discussed at that meeting more or less determined my planning for the rest of the day, and there was a lot of driving around, and a lot of work to be done. when asked whether at that meeting, 10 o'clock in Schnitzno, not in Donetsk, whether in Schnitzno at 10 o'clock there was talk about a book, Taylor Pulatov says, no, at that meeting, during those meetings, there was no mention of a book, no order with respect to a book. The only thing we discussed was the change of chain in command in that respect and the movement of our armed forces. And all this means that Pulatov on 17 July 2014, as from 10 a.m. in the morning more or less, did not have the command of the area of which prosecution says that from which the prosecution says that a book missile was fired, which I would say is important. The power of disposition mentioned in the prosecution's address, and the prosecution understands this to be the choice as to where the book teller is led to and positioned, and the choice to shoot down an incoming plane, words of the prosecution, knowing that all those on board will be killed. In connection with that, Pulatov on 17 July, that power of disposition is moot. According to the prosecution, DPR consists of different units, and each unit more or less has its own territory, but they do have a clear hierarchy between or among the fighters. If the command is taken over by someone else, such as CAP, you simply have no say in the way in which the military operations are carried out in that area at that point in time. And this also explains why, from the very moment CAP takes over command on 17 July, why there is relatively little telephone traffic in the case file with the number 511. So from 9:55 a.m. onwards, there are just two short conversations, one at 12:42 and one at 12:51. I'll be discussing these conversations in further detail in a moment. And from 13:26 to 17 hours 18, there are no conversations on this before. And this actually fits the situation in which someone is in reserve and is not actively involved in combat action and is taking a couple of hours to sleep, to rest, and eat. And in several other telephone conversations, you can see this in the case file, we see that people are not communicating simply because they're taking a nap. We see this quite frequently. Nonetheless, Pulatov, after lunch, starts working on a number of supporting activities, and these are not operational combat actions because he simply doesn't have command over these combat actions at that point in time. No, this is the execution of the instructions that I referred to earlier on concerning artillery fire. In his second video statement, my client, when answering the question what he was doing after lunch, he answers the following. So one of the main goals that I was working on that afternoon was the fact that we were receiving a number of tanks for our support. So it was my personal goal to make sure that these tanks were okay. I was responsible for designating the tanks to positions, supplying tanks on that position, and I also had to take care of the tanks, making sure that they were hidden and camouflaged so that they would be safe for commanders about the availability of these tanks. So that's what I was working on. I escorted a convoy of these tanks to their locations and also escorted them first to Surovka, and from there on I moved the tanks to Stepanovka. And I also made sure that the other commanders were aware of this, and we discussed matters. From there on, we carefully moved them in the direction of Stepanovka, hid them under the trees so they couldn't be seen from the sky. And subsequently, the commander was given the instruction to meet the commanders that he would be working with, while I, in the meantime, also needed to solve other issues.
And this is where Pulatov said such his coordinating role between various groups, as I talked about on Friday. Aside from the fact that Pulatov was no longer in charge from approximately 10 a.m. on the 17th of July, he'd also received no separate command to guard the book or have it guarded. In section 16 of my pleadings on Friday, I mentioned this, Conversations I will discuss later reveal that the people the prosecution calls guards were only in contact with Karchenko and not Pulatov. As far as Pulatov is concerned, then, there is no proof that he has had a book tailor guarded or concealed, and I'll now go into that in greater depth. The people the prosecution says were involved in guarding the book tailor are only in touch with Karchenko. The only piece of evidence the prosecution can put forward connecting Pulatov to guarding is a telephone call of 9:55. Pulatov asserts that it's a deception call. And in the light of the phone call 1 minute before, it's also an incomprehensible conversation, because in that conversation, the prosecution says Dubinsky orders Karchenko to guard the book. And, according to the prosecution, Karchenko carries the order out. In Donetsk, he takes over commanding the convoy, and, according to the prosecution, he commands his inferiors to go to Borbaiske and orders Sharpov to guard the book tailor. Now, Dubinsky's orders often led to confusion, as we can see from the conversation between 511 and Karchenko at 7:05 a.m. on the 17th of July 2014. In the translation it says, "First I am assigned to be a man in charge, then crap, you get a different order." And I'm saying that in relation to what I'm about to come on to. In order to understand the real meaning of what Dubinsky said, we can't simply rely on phone calls. No, you have to look at what his inferiors actually did. As regards guarding the book tailor, according to the prosecution, only Karchenko emerges prominently, which leads us to suspect that the supposed discussion of the 9:55 phone call was not followed up. In reality, if you don't see it as being a deception call. Pulatov himself could not be clearer about this in his video statements. He did not receive an order to guard the book tailor, let alone give orders for it to be guarded. And prosecution thinks that it can solve this question in its statement by suggesting that they must have received the order to guard the book together. But that's not the way it works in a hierarchical structure, and the prosecution has put facts forward which prove it didn't happen. Furthermore, it doesn't make sense for 2 units to be involved in guarding 1 piece of air defense artillery. At a secondary level, I would add that receiving an order does not go to prove that you've proved that the person actually did carry the guarding task out or got someone to do it. It's easy to read that into the facts, but it isn't proved. And there is no such proof. There's no conversation involving Pulatov with anyone at all in which he gives any order for the book to be accompanied, guarded, or concealed. And this also doesn't follow on from what the prosecution themselves say in their statement. Dubinsky's conversations with Chernik, Semenov, and Pulatov immediately afterwards show that it was Karchenko who got the order to accompany the transport of the book tailor. And accompany is not the same thing as guard, but it comes close to guarding within the meaning of the charge sheet. Now, interim conclusion regarding the command structure relating to guarding the book. On the 17th of July 2014, roughly 10 a.m., Pulatov was therefore no longer in charge in the area which the prosecution alleges was the book launch site. The prosecution says that on the 17th of July 2014, Pulatov was one of the commanders in the field, is thus incorrect. In addition, there is no evidence to support the suggestion that Pulatov used his position of authority, as the prosecution put it, to guard the book-tailor or have it guarded or concealed. There is no factual evidence for that statement. Now moving on to the timeline regarding when the book-tailor allegedly arrived in Snizhne, particularly regarding Pulatov. This is section 1.15 of my pleading notes. In addition to the guarding side of things, the prosecution then goes on to say that on the basis of two conversations at 12:42 and 12:51, the phone calls with number 511, that Pulatov, I quote, shortly before 1 p.m. meets the book convoy with Karchenko by the fourchet in Snizhne. The prosecution bases this mostly on the two phone calls I just identified. The prosecution therefore says that Pulatov did see a convoy with a book, but these two conversations themselves, Your Honour, do not prove this, and there's no further evidence to back it up. In addition, the timeline, which I will now go through, shows there is no clear evidence that a book-tailor was present at the fourchet in Snizhne at around 12:40 to 12:52. On the contrary, the evidence on that issue is self-contradictory, as the court has already noted, I understand. I'm now going to look at the timeline. And as far as I'm concerned, the timeline begins at 11 a.m. on the 17th of July and finishes approximately 2 p.m. Between 11 and 1:15, there are witnesses saying that they saw a book-tailor in Snizhne after 11 a.m. Some saw it by the fourchet, by Uholok Cafe and a park, and this continues until 1:15 p.m. Shortly after 11 a.m., witness S17 sees a book convoy in Torres, not Snizhne, Torres. 11:36, Karchenko informs an unknown man, and I'm already near Snizhne. 11:39, a book-tailor is videoed on Zures, and according to the video's data, it appears to have been filmed at that time. 11:41, Karchenko says again on the phone that he's getting close to Snizhne. Round about 12 noon, we can read that a book-tailor is videoed in Torres, which seems to have been recorded round about noon. Now we move on from 12 to the time slot 12:34 to 12:47. In Torres, a book-tailor was also photographed, and the photograph may have been taken between 12:34 and 12:47. And this is really rather different from what witness S17 says he saw in Torres. He says that he saw the book convoy there shortly after 11 a.m. That's an hour and a half earlier. Now, one of the documents on file, the primo number is there. The location where the book-tailor was photographed in Torres is roughly 11 kilometers away from the fourchet supermarket in Snizhne. The journey between those two locations takes around 14 minutes, according to Yandex. That's what we see on file. Well, that would mean that if the time from in the time slot of the photo is correct, and traffic between Torres and Snizhne wasn't delayed in any way, the book-tailor would have moved between 12:48 and 13:01, could have arrived in Snizhne. However, We've done the sums. And what we come up with between those two locations is that it's not an 11-kilometre distance, but it's a 12.2-kilometre distance. In addition, we've started from the average convoy speed as set out by the JIT, which is 43 kilometres an hour. Which means not 14 minutes, but at least 17 minutes. And that's even in the best possible traffic situation, because of course we don't know whether there was congestion or not. And we can also explain this mismatch from the fact that Yandex and Google Maps calculate this kind of thing by looking at the maximum permitted speed on the roads in question. You can't adjust the speed to something lower. The time margin for arriving in Stijne therefore shifts to 12:51 and 13:04. Now 12:42. This is the first conversation between Karchenko and phone number 511. The prosecution and the JIT imagine that at this time the book-tailor had arrived at the Forchet in Stijne with Karchenko. On the basis of the KNMI's calculations regarding the Torres video and the journey time from Torres to the Forchet in Stijne, the book-tailor would have arrived, or could have arrived, at the Forchet in Stijne between 12:51 and 13:04, as we calculated, and thus not at 12:42. In addition, even if we do follow the calculations of the JIT, although they are not correct, I think, the fact remains that these calculations mean the book could not possibly arrive before 12:48. That's starting from 12:34, the beginning of that time slot, and that's 6 minutes later than 12:42. In addition, the JIT takes it that Karchenko was always close to the book-tailor, but there is no that 12:42 is the time at which he arrived with the 3 Vostok tanks. It is therefore not correct to assume, as the JIT does, that the photo was taken in Torres before 12:34, because one of Karchenko's telephones had already contacted a mast in the centre of Stijne at 12:42. That's quite a lot of assumptions without any firm evidence. In addition, you can see that the KNMI's calculation does not suit the JIT, and they decide simply to disregard it. Now, I therefore have calculated the time slot 12:51 to 13:04, and that does not match with what a number of witnesses say about the time where they saw a book-tailor in Stijne, or say they did. And here the witnesses who say they saw the book-tailor a couple of days earlier can be disregarded. So that it varies between 11 to 12 o'clock, or 12:30, and sometimes from 11 to 11:30 a.m. So 12:51. This is when the user of phone number 511 says he has arrived next to the fourchette. He is asked whether he can see a trailer, and he replies, "No, I can't see anything." Now, only in the best situation could this be the very first time, on the basis of the KNME having calculated the video in Torres correctly, this is the earliest time at which the book-tailor can arrive at the fourchette. If there was even slight congestion on the road, the book-tailor could not possibly arrive until after 12:51. Furthermore, there's a margin of 13 until 13:04, in other words. So the chance that the trailer was not there at 12:51 is very much more likely. One minute rather than 13 minutes. Now 12:56. At this time, Dubinsky is telephoned by an unknown person and told that Stary has set off with a trailer to unload. According to the JIT, Stary means Semenov, and Stary is Karchenko's chauffeur. However, the 12:56 conversation leads us to deduce that it's two different people. In the conversation, there's another C person, and we don't know who that is. The great question is whether this phone call refers to the book tailor or something else. We do not know. It's all kinds of speculation we've heard, but there are no facts. Then 13:07 to 13:33, so 7 minutes past 1 till just after 1:30. This is the time slot which the KNME indicates for a photograph showing a book tailor driving under its own power can be seen in Snizhde. Says the KNMI if the photo was taken on that date. A self-propelled book, means that it has been unloaded from its trailer, and that, therefore, could have happened between 13:20 and 13:25, because that fits in the time slot we're talking about, and that is not the time slot in which the user of phone 511 says he is at the fourchette. It could have been earlier, but we don't know. The exact moment of unloading, if it had already happened then, and if it is in connection with the book, is not known. The KNME carried out a second investigation and corrected the time slot for this photograph to 13:12 to 13:47. It was 13:07, 13:43, now it's 13:12 to 13:47. So, what about 10 past 1 to 1:15? Witness V51 sees some material driving under its own power. He's never seen it before. 13:11 to 13:58. According to the KNME, the video images of a self-propelled book tailor near Snizhde may have been taken between 13:11 and 13:48. I think that's a mistake. Just one moment. 13:58. And the KNME says if the recording was made on the 17th of July 2014. But this time slot is incompatible with the corrected time slot for the photograph, because the location where a tailor is visible on the photograph comes before the location where you can see a tailor on the video. On the basis of this, we must conclude that the videos were filmed later than the time calculated by the KNMI. The precise date when these images were made has never been proved. Next, 13:12 to 13:47, this is the corrected time slot calculated by the KNMI for the photograph in Snizhde that I mentioned a moment ago. So we've got a great deal of evidence which is incompatible on the timeline, but we also don't know exactly where a book tailor, on a trailer or not, was seen in Snizhde around 12:51, if it was already there. Was it, as many witnesses have said, on the little square before the fourchette? Beg your pardon, what no witness says, or was it standing to the south of that square, near the Uhulok restaurant, as V22 says, around 1 p.m? Or was it in the centre, near a park, without a trailer, as V7 told the investigating judge, and that little park is approximately 700 metres southwest of the square? According to V7, the book tailor was there between 12:45 and 13:15. If that is correct, then, according to the prosecution, Pulatov, or better, the user of phone 511, cannot have seen it at 12:51 because of the buildings blocking his view near the fourchette. You can see that very clearly by looking at the Google Maps satellite images of those two locations. 700 meters distance with a lot of buildings in between, and if it was standing by the fourchette, you wouldn't have seen it from the park. In addition, concerning the 12:51 phone call, comparative speech analysis does not establish whether the voice we hear in the conversation may be Pulatov's. The conversation did undergo what we call mother tongue speech analysis and blind analysis, but not in the computer analysis. The analysis that was done states that there is no firm interpretation because there are insufficient recognizable characteristics in this short recording. In the blind analysis, this corresponding conversation, B8, is sectioned in group 3. This is the group where we are told that there is a normal degree of certainty that the speakers are not the same in the 4 groups. In the mother tongue speakers analysis, the second researcher, B8, does not place conversation B8 in group 8, where he believes they're all the same speaker. The conversation of 1242 is not assessed in comparative speech investigation. Against this background, I'd like to remind you that Pulatov's video statement in October said, "Some of the voices I can recognize myself and some I cannot." It was also quite useful in the militia to swap phones and SIM cards amongst ourselves. And this is why, as I said before, earlier in this presentation, we have responded cautiously as to whether or not our client recognizes that he really had those specific conversations. Regarding the 1242 phone call, this was put to him in the second video statement as an example of a conversation where code language is very obviously being used. After listening to the conversations recorded, he said only that code words were being used, but he does not confirm that he is speaking himself. He explains that the word translated into Dutch as toy is normally used to refer to some kind of portable device. And this explanation is quite plausible if you look at other conversations in which the Russian word igruska is used, and that means toy, as we now know. An example would be the conversation at 10:13 a.m. on the 12th of July 2014, where they talk about an igruska, a toy, and they talk about the manual for it, which is being printed. Now that wouldn't be a book tailor, but in fact it would be some kind of portable device. And because this conversation was only made available for inspection, I have inserted a copy of it in my pleading notes, and the whole text is in my pleading notes. It's not very long, I will refer you to it. And this brings us back to the two conversations, 1247 and 1251. Now here, the name Oleg is heard at the beginning, but that doesn't really serve to identify anyone. Particularly because at 1309 there's a conversation between Karchenko and a person calling himself Oleg in that conversation, according to the English translation. In that conversation, they talk about the last checkpoint leaving Snizhne before Stepanivka. And Pervomaisky turns to be at the first checkpoint. We will meet there somewhere. This conversation is not thought to involve Pulatov. And it isn't carried out using any of the phone numbers connected with him. And this really does raise the question, is it not this other Oleg who Karchenko wanted to meet shortly beforehand at 12:51 at the Fourchette, and who clearly was still having trouble finding where he could meet Karchenko another time? Not on file, and was only put on file in response to a defence request. That's Annex 6, which you'll find in my pleading notes. And all this put together means that as far as we can see, the conversations of 1242 and 1251 do not provide any convincing proof that Pulatov was involved in them. Now,
This timeline should lead, first of all, to the conclusion that many sources of evidence are not compatible, which by definition makes this unreliable. Second, only very generally a time frame can be reconstructed within which the bookteller was presumably in Snizhnoy. And that is a very broad time frame which starts at 11 and ends at 1347. And I haven't even mentioned other statements stating about that.
Within a large part of this time frame, we have to assume that the bookteller was also present in Torres. And within this time frame of almost 3 hours, the user of number 511, according to the text of an intercepted conversation, was only at one specific location at Snizhnoy, which is where the bookteller is suspected to have been as well. The transmission mass data, as pointed out, cannot give us a precise answer in terms of the exact location. Members of the bench, needless to explain that the sources of evidence contradict each other and that everyone can glean from this whatever they want, prosecution, defense, etc., but the outcome is insufficiently reliable. By requesting to examine the witnesses, we, at the very least, try to establish what exactly happened there. And the chance that Pulatov, that is linked by the prosecution to, in the conversation of 1251, chance that Pulatov actually saw the bookteller at Fourchette is incredibly small. We don't know exactly how long Pulatov stayed there at that location, even if he was there, and we cannot determine whether or not he left once he saw the tailor. But the chances are that he never saw the bookteller, and I'm going to use the probability terms of the NFI, is more probable, or much more probable, than that he did see it, particularly in view of the time frame in which the bookteller would have arrived there. And that time frame would shift to 1251 should there have been any delay in the traffic from Torres to Schnitze. And also the fact that the bookteller could just as well have been at a different location than the location where the user of number 511 was at 1251. And since it was a war zone, it is not theoretic at all to assume that there might have been some sort of traffic delay. Pulatov himself stated that on 17 July, he did not see a bookteller, and that in the conversation of 1242, code words are being used, and he explains what toy and that means portable device. And the correctness of this position cannot be ruled out, also in view of the contradicting evidence. And in terms of evidence, all this means that the assumption of the prosecution that Pulatov just before 1300 hours meets the book convoy with Karchenko at the Fourchette and Schnitzoy can simply not be proven. And the more alternative argument that one could put forward in this respect is that simply meeting Karchenko around 12 hours 51 p.m. and then possibly seeing a bookteller is still not instrumental for the charges and what we read in the charges in the 6 factual descriptions of those actions, nor does it constitute an essential element of contribution for perpetration. But this is something we will be discussing this afternoon, as well as other forms of participation. By way of summary, Your Honours, I have included another time frame of the most relevant sources of evidence, and at one glance, I think we can see our conclusion of incompatible evidence. Now, a few words about conversations after the crash, and I'm trying to follow the chronology of that day. The subsequent conversations after the crash on number 511 are of 1718 hours, 1749 hours, 1752 hours, and 1836 hours. These conversations do not refer to the crash, but in these conversations, information is exchanged about positions taken by the DPR, similar to many other conversations to that effect. If Pilatos, as the prosecution assumes, was so intensely involved in deploying and or guarding the Butela, or had known about it, as the prosecution is assuming, if that were the case, then his conversations in the first 2 hours after this horrific event would have painted an entirely different picture with respect to the alleged responsible persons for this disaster. Pilatov himself said that immediately after the crash he went to Grabovo to help at the crash site. Wouldn't he then, in the prosecution's version, wouldn't he then have made a phone call to the alleged crew in order to ask what on earth had happened? And about these alleged contacts with the crew, well, I'll be talking about that later on. The first conversation after the crash, that is indeed about the crash, is a conversation held at 1844 hours. From this conversation, we can infer that the speaker on number 511 himself doesn't know what happened, but someone else has informed him. So this is hearsay information. And this also follows from the conversation held at 1952, in which the 511 speaker on 511 says that he was at Marinovka when the Shuska was hit. In Mr. Duschat's oral arguments, she explained in detail that actually at that time nobody knew exactly what had happened, that there was a lot of speculation among the separatists about what had happened. This brings me to a different timeline, and this is what I call the timeline for requesting a book tailor. Earlier on in these oral arguments, I announced that I would be discussing this in depth, and also what can be inferred from the file as to when requests were made for proper anti-aircraft weaponry and who made those requests. According to the public prosecution's address, this starts on 8 June 2014. That is a conversation between Girkin and Aksionov. The very next conversation after this that the prosecution refers to in this connection is a conversation held on 13 to 14 July 2014. And the context of the conversation is obtaining an anti-aircraft weaponry system in the night of 13 to 14 July 2014. The JIT identifies many individuals in connection with this event. Pilatov is not involved. The official record describes that the JIT suspects that in the night from the 13th to the 14th July 2014, an anti-aircraft weaponry system has been brought to the Ukrainian territory that seems to be leaking oil, and the tailor then burns down in the evening of 14 July 2014. The JIT argues that during the day and the evening of 14 July, there are two telephone conversations that take place between high-ranking separatists, not Pilatov, and that concern a book missile system. In this conversation of 14 July 2014, one of these persons would have said that an Antonov 26 or 30 was shot down by a book. The Military Intelligence Service, according to the JIT, reached a conclusion in a report that it's not likely that the Antonov 26 was downed by a book tailor. Should this information of the Military Intelligence Service be correct, Your Honours, then the conversations that are mentioned by the JIT on 14 July 2014 would be deception calls. And furthermore, the official record refers to a suspicion that on 14 July 2014 a vehicle caught fire and that now a new vehicle needs to be brought in. The burned down vehicle, due to all the logistic problems, in any case would remain for 17 July 2014. Pilatov was not involved in the presumable request for the anti-aircraft systems, and this may seem boring, but that's the case it is. Same applies to the transport that, according to the prosecution, would have taken place in the morning of 14 July 2014. This convoy would have consisted of 4 tanks, 3 artillery vehicles, an armored vehicle, and a white truck with a white trailer. When the court presented the documents, the court presented and referred to conversations held on 14 July and 11 July 2014, in addition to what the prosecution had referred to. In these conversations, Pulatov does not take part either, nor do these conversations refer to specific anti-aircraft systems, and so no book is mentioned there either. In view of all these circumstances, one cannot safely say that the conversation held on 16 July 2014 at 18:12 hours, in which the caller with number 511 for the very first time throughout this period from 8 June onwards, for the first time refers to the fact that a long-range artillery and a proper anti-aircraft system is necessary, that this would be the direct reason to supply a book system. I have already shown that this decision had taken long before this conversation ever took place. The circumstances that were presented, and also the conversation of 18 hours 12, we can infer that Pulatov is referring to the material or the equipment required from his intelligence duty, in view of his intelligence duty, and not his alleged duty in terms of anti-aircraft defense. In the personal file of Pulatov, there's only reference to a couple of conversations, particularly with Kuritz, who, according to the official record, would be a commander of an anti-aircraft unit. Now, if that is correct, then he, Kuritz, is in charge of anti-aircraft defense and not Pulatov. Contacts with him, insofar as we can establish that Pulatov can even be heard on the line, those contacts take place in the context of gathering intelligence that Pulatov, as he explained, then shared with other commanders. And now the chapter that Pulatov is not the link to the crew. And now I'd like to proceed to another topic in the prosecution's address. Several places in the prosecution's address, the prosecution says that Pulatov is unsuccessfully trying to get in touch with the crew of a bookteller. And this would be a number that ends on 6335. It really seems that the prosecution in its address forgot what it had put forward in the presentation of the prosecution on 9 June 2020 about this topic. Because at the time, the prosecution said that there were indications had been found that this number 6335 was part of a series of telephone numbers that were being used by the DPR and were provided to crew members or escorts of the teller. But the prosecution then said the following. When the summons was issued, we could not yet foresee how the investigation into this topic would proceed. At the same time, we knew that an indictment in cases tried in absentia is not easy to supplement. For that, there needs to be an interruption of the trial, and the additions to the indictment need to be served to the defendant, and that would lead to an undesirable delay in the proceedings, which is why it was decided to make sure that this part, the putting at disposal a telephone with a Ukrainian number, to include that for the sake, just to be sure, to include it in the indictment of the four defendants. And then the course of events in this presumable supply of a telephone is, and this is in June 2020, is for the time being not clear enough in order to declare this specific point proven. So, according to the prosecution, this item in the charge must be acquitted. After providing the primo case file to the defense, no additional official records were added from the case file. And that means that the state of play with respect to this item has not changed vis-à-vis the date on which the prosecution presented the position that I just quoted. And this makes it clear that this element is also, in the view of the prosecution, an incredibly weak link in the chain of evidence. And we must take the prosecution up on the promise. The prosecution's address, this point, the acquittal with respect in this respect, is not reflected in the public prosecution's address. So we just assume that this is an omission. And the comment in the prosecution's address that there is no evidence for a relationship in the sense of subordination between the 4 defendants and the booktailer crew is also quite telling, but that doesn't include specifically the fact that there is no evidence that the defendants have nothing to do with making a telephone number available with a Ukrainian number. This evidence, by the way, is not there, does not exist, but that has not been confirmed in the prosecution's address. So we expect, in reply, we expect the prosecution to correct that.
Now, the interpretation of some of the conversations conducted in the evening of 17 July 2014. I think I have enough time for this bit. The judge agrees. Now, back to the prosecution's address. The following is also remarkable. That in relation to the number 6335, the conversations would have been about a booktailer is conveniently inferred from the words of the fighters in the new box. The prosecution's address does not argue that it was proven, but by the words given that, the prosecution assumes this. According to the prosecution, the words of Kharchenko in a conversation on 9:40 p.m. with phone number ending in 511 followed virtually immediately after the conversation took place with Gilasov. The available data reveal that 8 minutes elapsed between these two conversations. This is important because, admittedly, it appears that the two conversations are related, but in fact, especially from Pulatov's perspective, that is not the case. To explain this, we need to go back to 15 and 16 July 2014 first. On that date, the separatists seized a tank from Ukrainian armed forces after taking Stepanovka, and I'll show you 2 photographs of this, and the primo numbers appear in the footnotes. The phone calls also mention this seized tank in a conversation on 17 July 2014. Girkin and Dubinsky mention a tank that we have that is damaged and needs to be evacuated, and specifically needs to be escorted by some APCs. They promise to wait for it at the provincial border. In a conversation at 8:32 p.m. between Dubinsky and Kharchenko, they also discuss APCs, and that one is broken, and the second one, he gave an order to take them out of the village so they won't be destroyed by bombs. This conversation is also mentioned in translated to English, that box. The Dutch translation uses a word meaning little box. A footnote for the Dutch translation indicates presumably a vehicle, tank, weaponry, APC. Next, at 8:41 p.m., a person named Oleg calls. And once again, this is not Pulatov, but somebody identified as Zmei Sharpov, who tells Kharchenko they're taking the box away. In the English translation of this conversation, in the footnote at box, we read military slang for a piece of armored military equipment such as a tank, or BTR, meaning APC. The Russian word for box is korobosha, and Pulatov also translates this as a tank or some other armored vehicle. And in any case, that would not be a booktailer. Afterwards, there were many more conversations, but only at 9:40 p.m. is another intercept recording found for number 511. And the information shared in all those earlier conversations is unknown to the user of number 511. At any rate, nothing is apparent of this. The conversation at 9:40 p.m. reveals that the user of number 511 does not immediately understand what the issue is. First, he thinks that this concerns one of his soldiers, and Kharchenko uses the term korobosha, meaning box. The entire previous course of events on 17 July is not known to this person at 9:40 p.m. This is an important observation because in the link the prosecution believes it can make to a previous conversation, it overlooks that the user of 511 does not have the same perspective of Kharchenko, as clear from this conversation. At the second video statement, we presented this conversation to client and asked how we should understand this. He says that there is a new box and the combatants in it. Basically, this is equipment seized, so a new trophy, and he wonders where you can get the personnel to operate it. Client explains that in that case, generally the people removing it are mentioned, and fighters, in his view, could mean the crew that was captured. In stating request for investigation in 2020, prior to recording the second video statement, we already noted that client suspects that if he did try to contact 6335, this may have related to the tank previously seized. Now, once again, looking at the translation of these types of conversations, it's clear that because of the coded nature, these conversations do not initially seem very logical or understandable. That's what makes it so important, if you want to use them as evidence, that the participants identify them. Without such identification and description, conclusions are risky. Now, I will continue talking about the number ending in 6335. At the hearing on 3 November 2020, to substantiate the view that the number ending in 6335 relates in no way whatsoever to the crew of the alleged book, we requested that all witnesses that might be able to say something relevant about it be interviewed. These are members of the 53rd Brigade, Gilazov, Kharchenko, Dudnichenko, and Sinenkov. It's known about Dudnichenko that, according to the case file, he conducted the 60-second call with number 6335. But the case file does not contain an audio recording of that conversation, which is why we made that request, as well as for 7 SMS messages from that number. In response to this and the investigation request, the prosecution said that interviewing Shinenkov was not relevant, and that the 60-second call and the 7 SMS messages were never intercepted. In an interlocutory decision in November, your court granted an interview with these members of the 53rd Brigade, but not an interview with Shinenkov for lack of interest by the defense. The interviews instructed that for the witnesses that were granted never took place for various reasons. Given that the prosecution in the participation structure is substantially more focused on the argument that Pulatov was the link to the crew and bases this on the failed conversations between the numbers 511 and 6335, denying the request to interview Shinenkov now seriously infringes on the rights of the defense. I'll explain why. The Primo case file considers 9 numbers which are identical except for the last 2 digits, and states the suspicion that number 6335 was used by the crew or by an escort of the Book Taylor crew. Number 6335 is said to have been active only on 17 July 2014, according to the case file, although calls were also made to that number on 19 August. The as to the relevance of ascertaining that besides 6335, 8 more numbers had the same last 2 digits, that goes unexplained. It is not known, for example, whether additional numbers used by the DPR were similar or were part of a series, and whether this was unusual in some way. Nor does that report indicate which phone calls were recorded between the other 8 numbers, or their number of frequency or the period within which this took place. The report notes only that investigation primo does not have the historical communication data for 6 phone numbers. Whether they exist remains unclear. As for not knowing the masts with which 6335 communicated, as well as the evening attempts to contact this number, with respect to that, the court, in presenting the documents, already noted that the JIT infers from not knowing the mass data of the 6335 number, infers that the book teller was concealed somewhere. And that nicely exemplifies the preoccupied angle of the JIT, because the historical communication data of the provider of 6335 reflect no so-called zero contact. That's why the mass data are not known. There is no other reason. Moreover, one of these numbers was used by a DPR combatant named Sinyenkov, and not, even if that were the idea, it was not used by members of the 53rd Brigade. According to the report, this Sinyenkov contacted 4 of these numbers. How frequently and when is not mentioned in the report, but based in part on his contacts with 4 numbers, it is suspected in the report that Sinyenkov appears to be a link with some of the above phone numbers. But weren't these 4 numbers simply being used by DPR combatants, and doesn't the same hold true for the other numbers that followed? Since the prosecution's address expressed the view that Pulatov was the link to the crew, there is ample reason to question Sinyenkov about that position. If he were to state that it was not Pulatov but himself, that would be very exculpatory for Pulatov, and the prosecution's argument will be refuted. If you intend to assume that Pulatov was the link to the crew, we are conditionally requesting that Sinyenkov be interviewed as a witness. Should your court attribute any significance to these murky suggestions and suspicions of the JIT and the prosecution, it is alternatively relevant to indicate that there is no evidence of Pulatov having called 6335 himself, which is conveniently assumed in the prosecution's address. The print list reveals only a registration of that number, not of Pulatov personally. As for the partial conclusion about this part, the argument concluded in the prosecution's address that the user of number 6335 may be concluded to be in contact with the book Taylor crew or with one of the crew members cannot possibly be proven.
waits until a predetermined time slot to activate the radar, and after subsequent orders from superiors or from a spotter who says that the target is approaching. Further down we see, on the basis of the mission task, and having received higher commands, the TAILOR commander moves to the first stage of preparedness. Once the autonomous TAILOR has a communication line with higher command, the TAILOR commander communicates parameters verbally regarding potential targets, waiting for further orders. Once the commander is in touch with an AAMB, information might come regarding the type of target, depending on what the commanders were able to identify about it. If there is no contact, then the TAILOR commander himself will decide whether to continue. All this depends on the range of the predetermined mission task. Further down, the TAILOR commander himself decides to direct the TAILOR at a specific target. The TAILOR commander opens, and he does this so that the missile can be launched. If a TAILOR commander has received higher orders or decides to launch a further missile, then he holds the launching button for 3 to 5 seconds, which launches a second missile. In standalone mode, a TAILOR, as we see in the document, is always in touch with higher command, but does not receive direct or automatic input from a TAR or CP. The TAILOR uses this fire dome radar in order to soak in a sector identified by a higher command at battalion or brigade level. After a target has been identified, followed and locked onto in this sector, and all identification procedures have been gone through and all the parameters, which I mentioned earlier, have been identified, the information is passed on to high command, and that is where the decision to launch is made. In the report we can also talk about the ambush mode. Here there is no direct connection between the TAR or CP, the commandants. In that case, there are two options. The first option in ambush mode is that authorization to launch the missile is given before the TAILOR is deployed. That is to say, during the briefing before the TAILOR moves to the launch site. During the briefing, they are told that there's a particular target with specific parameters expected in a particular sector. The second possibility in ambush mode is to operate on the basis of other information from a spotter, for example. But the former commander, when interviewed, said that this was most unusual. When asked about it by the investigating judge, he said, no, there's no such thing at all, absolutely no. In addition, the same former commander was interviewed by the investigating judge in the Netherlands, and he says, in order to operate a book installation, you need to have a company, a brigade. And that is the 35th Brigade, according to prosecution. A brigade of this kind contains 36 marksmen, people with experience on the field, but the actual launch is carried out by 4 or 5 people. They carry out the actual launch. And then he goes on to what he talks the vertical structure for operating the system. And in response to that word, the vertical structure, the investigating judge says, do you mean a hierarchy? And he replies, yes, the hierarchy is very rigid. There is absolutely no freedom within the hierarchy. The investigating judge says, can you describe this hierarchy? And he replies, it's a very straightforward matter. No one is allowed to get involved with the battery. When reading out for the dictatorship, he adds, the battery commander is subordinate to the battalion commander. The battalion commander is subordinate to the brigade commander. The brigade commander is subordinate to the air defense commander, and the area air defense commander is subordinate to the supreme commander of Russia. This is what he said. It is a very strict hierarchy, and no one from outside can get involved in it. The investigating judge then asks where all this information comes from, and the witness says, from my experience in the military and also my knowledge of the military academy. I also got genuine experience of armed activities. In other words, I want to say that it is unimaginable that someone would just get the idea of going off somewhere and launching a missile. The thing is, in addition, that the book system is a confidential system. It is kept very secret. Every system is equipped with the IFF procedure, so nothing can get out. Then there are the missiles. It's simply impossible to imagine that any old commander would head off to Donbass to launch a missile. And then the investigating judge asks, when using a book system, do they always observe the strict hierarchy? And the witness says yes, no exceptions. When asked about his statement to the JIT, he's asked whether the pre-designated target and mission objective are discussed in a briefing prior to the book tailor being brought into the launch location to launch a missile. Reply, yes. According to that, during that briefing, is a sector specified in which the target is expected to fly? Yes. Are the characteristics of the target described at the briefing? Reply, yes, we call it recognition characteristics. Then, later, he's asked, why would the tailor commander, as you say, never fire if a target appears with a different point of the compass? And his answer is, what I meant to say was that the tailor commander would never shoot at a target which doesn't have the parameters and base data that are indicated in advance. Altitude, speed, azimuth, these are the basic data which he must get for detecting a target. Otherwise, the commander will not do it. He's then asked, why does the commander not do it? Is that because of the hierarchy? And he replies, yes. A task or order is issued, and you act within that command, within that order. Our conclusion, therefore, Your Honour, in the light of all these quotes is as follows. It is quite absurd to imagine that Pulatov or any close-knit group of criminals, of suspects, actually had command over the book tailor within the meaning of the prosecution's words. Now, my last section. I'm saying it is called he was not involved at the beginning and subsequent events. This brings me to the end of this section. Finally, it's important that the prosecution statement made clear that Pulatov, according to the prosecution, was not present at the start of the beginnings of the events on the 17th of July 2014, nor in the subsequent events. The start, according to the prosecution, was the meeting in the morning of the 17th of July in Donetsk. Our client was not invited to the meeting. He was somewhere else, at another meeting, talking about something else. After this happened, according to the prosecution, Pulatov was not involved in the hierarchical change of command returning the book tailor. The prosecution says in its statement, if it is not clear what should happen after that with the book tailor between the launch site and Snizhne, it is discussed a great deal in the hierarchical line Sharpov, Vyakharchenko and Dubinsky to Gherkin. Our client's name is not mentioned here. There is no evidence of any actual Pulatov involvement in bringing the book tailor back. That speaks volumes and tells you a lot about Pulatov's role. So our client was not involved between 10 and 4:30 approximately, but Pulatov was not, because of his rank, involved in the beginning or end of the events in the indictment. Thus, we cannot say that he carried a substantial or active contribution, that is to say, as a co-perpetrator, nor that he was involved sufficiently in the joint planning and organisation and carrying out of the activities, which would be a functional co-perpetrator according to the indictment, and also in the prosecution statement. Prosecution says here that the close cooperation of the 4 suspects in launching the tail-up forms strong additional evidence of that they were acting jointly. Nevertheless, Pulatov was also not involved in the removal. On the basis of everything I've said regarding Pulatov's activity, the only conclusion is that none of the actions set out on the indictment can be proved against him. Now, Ms. Tendulskata will go into the legal side of things later today. Thank you very much. Well, that was a long section. It's now 11:25. We'll have a break till noon, and then we'll start on the afternoon section. And you can then look to see when you think it would be most appropriate to have a lunch break. We won't go on past 1 o'clock. Okay, we'll have a break now until noon.
All rise. Please be seated. Court is in session again. And you have the floor, Ms. Tenduschata. President of the Court, members of the bench, members of the prosecution, ladies and gentlemen, let me first say a few words about today's planning. My plan is that after this part, there's going to be a small section which I have called Other Questions, and I was intending to cover that on Wednesday, but I do think it's more appropriate to address those other questions before I wrap up on Wednesday. So if we can make it, and I think we should be able to make it, I would say that after doing this part, so after the next break, I would like to address that. And the interpreters already have that text. It's just that I hadn't highlighted it in my planning so far. So let's see how far we get. But before I discuss that, I'll be addressing this section, which is evidentiary question 3, legal interpretation. And actually, this is follows on what Mr. van Eyck just argued. It's about the alleged role of our client. And before I discuss the details, and I will proceed to paragraph 1, the indictment requires some interpretation and reflection. Our client is being accused of being guilty in different ways of, 1, causing an aircraft to crash, and 2, murder or manslaughter. And he would have done this as functional perpetrator or co-perpetrator, or co-perpetrator of incitement, or co-perpetrator of complicity. I think we can safely say that this is a somewhat exotic and by no means simple indictment. Functional perpetration or criminal command responsibility, with some exceptions, almost only appears in economic offences and essentially is meant for economic offences. I'll be discussing the details. Functional co-perpetration in causing a natural person to crash requires an expansion of the generally accepted limits of criminal liability, let alone with respect to co-perpetration of incitement or co-perpetration or complicity. If we look at the charges in this case, and after having listened to the prosecution's address, one could get the impression that in terms of the question of criminal liability, it is not about what somebody did or did not do, him or herself. The prosecution, for instance, says, "We do not believe that these defendants pushed the button to fire the Buk missile." But the prosecution also says, the fact that they didn't push the button themselves is, legally speaking, not relevant. Now, this impression requires some tweaking. In legal terms, it does indeed matter what one has or has not done. This is the beginning and the premise of criminal liability. You are responsible for what you have done yourself or have failed to do yourself, or what you did with or for others or failed to do with or for others. But unlike the prosecution would have us believe, it is first and foremost about what you did or did not do, whether or not, with other people. there are forms of perpetration or participation that extend the criminal liability somewhat, that only, between inverted commas, only require an involvement that is to a greater or lesser extent removed from the actual commission and execution of an offense. Now, these are the variations that have been charged. My client is not being reproached of the fact that he would have fired the book missile. So these charges, these variables that do not require the defendant to have carried out the criminal offense himself, that still requires that that still means it is important what the defendant did or did not do. So what we're facing here in terms of the charges is the following. Is the responsibility and liability of the defendants and the contribution of the defendant in pushing the button so important that he is criminally culpable or culpable of participating in the sense of co-perpetration, incitement, or complicity? The prosecution finds answer to those questions in the actual behavior that our client is being reproached of. And these behaviors have been broken down in actions in the prosecution's address into 1, requesting the book trailer, 2, deploying the book trailer, 3, shooting or downing an aircraft with the book trailer, and 4, removal of the book trailer. And the factual behavior that our client would have carried out is what the prosecution infers from, my colleague just referred to that, only a number of conversations, telephone conversations, no witness statements, no fingerprints, no DNA material, etc. Just these telephone conversations. And these behaviors, with respect to the request, would boil down to reconnaissance and coordinating troop movements of the DPR and also stating the need for anti-aircraft defense. With respect to the second point, the deployment, our client would have given the instruction to guard and position the book trailer near Pervomaisky and try to contact the crew of the trailer. In connection with downing the aircraft, our client, in telephone conversations, would have claimed responsibility. And in connection with the fourth point, removal of the book trailer, once again, he would have tried to contact the crew. These alleged behaviors prompt the prosecution to draw a number of conclusions. The conclusions are that our client would have been the link to the crew, that he would have been pleased with the downing of the aircraft, and he and other defendants would have considered the trailer as their book. The behaviors, as referred to by the prosecution, cannot be proven in our view, and should that be different, the facts and circumstances that have been put forward cannot support the conclusions that have been drawn. In the previous part that was presented on Friday and this morning by my colleague Mr. van Eyck, this position was further substantiated and explained. He argued, amongst other things, that it boils down to the following, that the reconnaissance had nothing to do with a book, that our client did not coordinate all DPR troop movements, that the stated need for an anti-aircraft defense had nothing to do with a book, particularly not, and that was expressed at a point in time in which the book, according to the prosecution scenario, was already on its way, and that he did not receive instructions, let alone carried out instructions to guard the book trailer, and especially not that he would have tried to call a member of the crew. Furthermore, we have argued that those facts simply cannot support these conclusions. In other words, that those facts cannot constitute participating in a closely cooperating group, whatever that may be, that our client had no own interest in deploying a trailer, and that he certainly was not the owner of the trailer, and that he didn't have power of disposition with respect to the deployment of the trailer. I'd like to refer to the substance of our pleading notes on Friday and this morning. My colleague Mr. van Eyck already argued this. This leads to the conclusion that our client should be completely acquitted from the charges. And that is the end of the matter, really, because even if evidence question 1 or 2 be considered proven, wrongly so in our opinion, even if that were the case, that cannot lead to a conviction of someone who played no criminally relevant role whatsoever. And since there was no actual behavior in connection with causing MH17 to crash and taking the lives, there was no actual behavior with respect of, on the part of our client, that can only lead to acquittal. Nonetheless, the defense has the duty to nonetheless discuss the hypothetical and very difficult to imagine situation that one or more of the charges against our client could be proven. What would those criminal facts lead to in legal terms? These facts need to be criminally relevant facts. Would they lead to criminal culpability, being functional co-perpetration or participation in the offences as charged? Before we discuss those questions in detail, it's appropriate to clearly explain which offences we are talking about, which facts and behaviors. We're not talking about the actual conclusions of the prosecution with respect to behavior, nor is it about the factual acts that, in fact, are really interpretations of conclusions or certain facts. No, we're talking about the facts themselves, provided they could be even proven. In other words, this is about the substance of the telephone conversations that were referred to. Should they be attributed to our client, what would that substance then mean in legal terms? These telephone conversations and what can or cannot be inferred factually from those telephone conversations, that was already discussed this morning. I'd like to refer to that. In summary, our position is that, as we pointed out, if one could prove that our client participated in those conversations, that at most that would mean that there's an alleged knowledge of those conversations, the possible presence of an out-of-order tailor. The telephone conversations, from those telephone conversations, we cannot infer more than the following. If those facts could even be proven and could be attributed to our client, all it can lead to is that he heard that others spoke about the presence or the transport of a book, and that he thought and could think that these conversations were about a book that was out of order in the context of military deception, and that he had no involvement in that. Nothing more than that. The question I am going to discuss here is whether those facts, if they can be proven, lead to the charges as proven. Whether those facts or those behaviors can lead to functional perpetration, co-perpetration, incitement, or complicity in firing a book in order to down or cause a civilian aircraft to crash and to take the lives, deliberately take the lives of those on board. So I will be discussing each and every element and what would be required in terms of evidence. And then after that, after lunch, I'll be discussing the requirements for and the lack of evidence for intent or premeditation. I will always reach the conclusion, in addition to what we've argued before, that even those facts that the prosecution believe it can prove, even though they would be proven, in any case there is no evidence for committing and or participating and intent. First question, functional perpetration. I started my introduction of this part by correcting the idea that someone's own behavior wouldn't matter when answering the question about criminal liability. Well, the contrary is true. In the Dutch criminal law, the individual liability for one's own behavior is stressed. Risk and collective liability, in principle, are set aside. Usually, in criminal law, the issue is that we determine that the defendant himself has carried out the criminal behavior, in this case, firing a book missile. The criminally relevant behavior is always a matter of action or failing to act. It is evident that the individual who carried out the offense, in this case, so the physical perpetrators, it's clear that they are not standing trial here. It's also evident that the defendants that are standing trial here are not the persons who carried out the criminal behavior as charged. They have literally also, in the view of the prosecution, they did not push the buttons. Nonetheless, the prosecution considers them to be the perpetrators, and in an attempt to put forward evidence for their criminal liability, the prosecution is resorting to the evidentiary tool functional perpetration. This is an evidential tool for situations in which the defendant did not himself carry out all or part of the criminal act, but the defendant is held criminally liable because he should be considered as a perpetrator, not because he himself committed the offense, but because the physical behavior of someone else is attributed to the defendant being the liable, the responsible person. Evidentiary tools, by and large, are used in those cases in which, at first glance, there seems to be a lack of evidence. If, in the normal way, which would be ordinary perpetration, if one could never be able to prove the crimes committed in the normal way, one resorts to this evidentiary tool. Let me give you some examples. There is an example such as a similar fact evidence. So for every criminal fact, there is insufficient individual evidence, but you can link all the different criminal facts in order to prove the offense. And another evidentiary tool is that of conditional intent. If it is not evident that a defendant has knowingly and willfully acted, the court can establish that intent is proven because the suspect has deliberately accepted the considerable chance that something specific would happen. So functional perpetration is such an evidentiary tool. It is used in those cases in which ordinary perpetration cannot be derived from the evidence. And in all those cases in which evidentiary tools are used, we have to be vigilant and make sure that the minimum standards for evidence are not circumvented. In the case of attributing someone else's behavior to a functional perpetrator, for instance, we have to make sure that the functional perpetrator is not held liable for behavior that he had no control over, and so he wasn't able to influence such behavior. Attributing behavior of another person to a functional perpetrator cannot take place without any restriction whatsoever. The criteria, so these restrictive criteria, on the basis of which someone else's behavior can be attributed to a functional perpetrator, are sometimes called the iron wire criteria. In this judgment, the Supreme Court stipulated that certain actions could only be considered to be the suspect's behavior if the suspect actually controlled those actions. And so this is what we call criminal command responsibility. The Supreme Court requires a specific power of disposition with respect to the physical behavior and a certain acceptance of such behavior. This power of disposition, this first point, has to be related to acting in contravention with the law. In other words, the suspect must have had actual control over the criminal act of the person who carried out criminal action. And the second point, being acceptance criterion, has been expanded in the fertilizer judgment. Acceptance can also cover not acting in accordance with the caution that can be reasonably expected to prevent a criminal act. In this respect, we must always keep in mind that even in the case of functional perpetration, the suspect's own behavior, and possibly also the fellow suspects, are essential. The own behavior by means of which the functional perpetrators facilitate the commission of the offense. The functional perpetrator commits an offense via or through someone else, and that is why he is criminal liable. And that means that control over the action of the person who's actually executing the criminal offense is an essential condition in order to be able to attribute a crime to someone. It is not the only condition. One can infer from this formulation that the suspect's own behavior must be assessed first. The crime is attributed on the basis of the suspect's own behavior, and not only with respect to the relationship of authority. Otherwise, there wouldn't be functional perpetration, but there would be simple liability, which does not exist in criminal law. So if we apply all this to this case, it means that ultimately the question is whether our client's contribution or the client and the other defendant's contribution was such that we can say that he or they shot the aircraft out of the air, out of the sky, with all the consequences that entailed. Only then would there be a functional interpretation of the crime. And the evidence will have to show that and how our client or our client and the co-defendants have committed or brought about the charges, and that their behavior was important enough in order to consider them to be a co-perpetrator.
The prosecution's position is that our client is functional perpetrator or co-perpetrator. On the basis of the prosecution's statement, it is not clear whether the prosecution are applying the rules of criminal command responsibility in the evidence underpinning this position. On the one hand, in the written position that was not read out in court, there is the written position that these criteria are not always of application, and that therefore the power of disposition is not always required. On the other hand, the prosecution statement itself adopts the position that power of disposition is involved. We can see this from what the prosecution calls the circumstances it considers particularly important in assessing the data. According to the prosecution, it is the circumstances of particular importance in assessing functional perpetratorship are the factual knowledge, in advance knowing about the coordination of the trooping movements, saying air defence was needed, receiving the order to guard a tailor but not obeying it, the unsuccessful attempt to make a telephone call of someone who was not a member of the team, and also talking about a book as their book. Those are the alleged facts and circumstances which, according to the prosecution, justify the conclusion that the four defendants were a close-knit criminal group and had their own interest in the deployment of the book Taylor and had extensive authority over it and enjoyed extensive power of disposition over its deployment. And those conclusions, according to prosecution, allegedly make them functional co-perpetrators. Now, the position of the defence here, and I'll just say here, adding to our point that the facts and circumstances can't be proven, but if we talk about the legal interpretation of things, we're then talking about power of disposition. Contrary to what the prosecution might be trying to attempt to say, the power of disposition is essential for functional co-perpetratorship. The Hulu says, only where there is a certain degree of power over others within a hierarchical organizational context can responsibility for their physical activity be considered. Without such power, we need not even consider functional perpetratorship. End of quote. Now, in case law, there are some few exceptions, but these exceptions actually confirm the rule. In cases of this kind, they always involve special circumstances which offset the lack of power of disposition to an ample extent and must do so. So, quoting from one such ruling of an exception, the close involvement of the defendant in the physical behaviour carried out by another person. Exceptions of this kind are not relevant in today's case, and the prosecution statement doesn't allege they are. They also don't deal with the question of whether the firm offsetting of the lack of power of disposition applies. So I will therefore disregard these exceptions, and I'll go on to the normal framework of the rules applying to criminal command responsibility, that is to say, the need for power of disposition. Now, the construction of functional perpetratorship in Dutch case law, particularly, not only, but mostly applies to corporate civil law. The responsible people within a company can, under some circumstances, be considered functional perpetrators regarding crimes which their subordinates commit. They can therefore be, and they are the actual perpetrators. However, here, aside from the power of disposition, we are talking about the structure of an organisation, which is very important. In the case before us, to state the obvious, they're obviously quite unrelated to corporate criminal law. The organisation of the circumstances within which the crimes alleged in the indictment were carried out, that is to say, questions 1 and 2, if they are deemed to be proven, it is much harder to understand than is normally the case in business life. When discussing this section, the question of the power of disposition and the organisation within which the alleged crimes took place, we need to analyse the relation of authority, or of our client and the co-defendants on one side, and the person who actually are alleged to have carried out the criminal activities on the other hand. And here we must constantly bear in mind that we're not talking about authority regarding your own actions or the actions of the co-defendants. Those, the alleged activities of the co-defendants, are not the crimes involved. The crimes in the indictment are downing an aircraft and taking the lives of the persons aboard by launching a book missile with a book Taylor. The persons who may have carried out the actual crimes on the indictment are, according to prosecution, the Taylor team. However, if we're then asked whether we're dealing with functional perpetratorship, the relations of authority between our client and the other defendants against the crew, on the other hand, is vital. And here again, we run up against insurmountable problem of evidence. Nobody knows who the book Taylor crew were. Even the prosecution's investigations into this clearly didn't get far enough. The prosecution, in its findings, says so far has not added its findings to the file, and as far as we know, no court has ruled on the question of who the crew of the alleged Taylor were. And without knowing who the crew were, it is not possible to establish any kind of authority structure. The Supreme Court demands that this be known, as we can see from a ruling of 2005. There was a reference, among other things, to the fact that, I quote, nothing was established regarding the legal position vis-à-vis the actual perpetrators, that is to say, the ship's master and crew. And the Supreme Court said that these considerations by the Supreme Court show that for functional perpetratorship, the relations between the concerned persons and the persons actually indicted in the indicted acts must be precisely defined. Now, the power of disposition means, therefore, that you must at least know the relations between the functional responsible person and the person who carried an act out must be precisely defined. And that means that the lack of knowledge regarding the relations between our client and the co-defendants and the unknown crew needs to draw us to the conclusion that responsibility in the sense of functional perpetratorship cannot arise. And certainly it can't be proven. Even if it were established who the crew were, though I wonder how that could be done, but if that could be done, the conclusion that we have not met the requirements for criminal command responsibility and that therefore there's no functional perpetratorship remains unchanged. If the crew, as prosecution alleges, was a Russian crew of the 53rd Brigade, then, nevertheless, it is impossible to establish that our client and or the other co-defendants had any authority over them. The prosecution does say that the defendants had seized control of the tailor, and this suggests they had a kind of power of disposition over it. But there is, however, no proof of this whatsoever, not even in the evidence set out in the prosecution statement. In formal terms, you're dealing with a power of disposition which is not here. Our client, in 2014, was not involved in the Russian army and therefore had no formal authority over the alleged crew. As far as we know, there is absolutely no doubt about that fact. In material terms, however, he also had no authority over the crew. He simply had nothing to say on the subject. Here I would refer you to what Mr. Van Eyck said about this, with all the extensive quotes regarding the hierarchical structure that applies to every tailor crew. From this we see that if it was a Russian tailor with a Russian crew, then that crew, particularly when it came to launching a missile, was subordinate to no one other than the formal Russian officer, and that they would obey orders from him and from nobody else. They would not accept orders from our client, nor from anyone else in the DPR military. The second criterion for criminal command responsibility is acceptance. Acceptance implies that in any case there's a certain degree of awareness. The functional perpetrator must have had some knowledge of the fact that behaviours were taking place or were going to take place but did nothing to prevent them. He is, in other words, consciously negligent, and he fails in his duty to intervene. From the file, we do not see that the client was aware of the fact that on the 17th of July 2014, around 4:20 p.m., a missile would be launched. Here again, I refer you to what we have said in other parts of our pleadings. The tapped phone calls reveal that no one knew that a missile was going to be launched, and even after it happened, they were groping in the dark about why it had happened. Further, I would refer you to section 6.1, where once again we can see that our client only got some information long afterwards on the basis of what someone reported to him, and that the information he got might have been wrong. As regards any type of acceptance of the success, that is, accepting the launch of a book missile using a book tailor on the 17th of July, for any kind of acceptance of that, there is precious little evidence on file. Quite simply, we don't know enough about the who, about the how and why of the missile launch. If it is established that a Russian book tailor crossed the border with a crew, then there is nothing to show any kind of agreement regarding the use of the tailor, let alone a plan to launch a missile. And without an agreement or a plan, there quite simply was nothing that could be prevented in advance. So you can't say that there was a legal obligation to intervene. You can only have such an obligation if you know that an alleged action may take place, in this case, launching a missile, and there is no evidence of that. My conclusion here then regarding functional co-perpetratorship is that we can't see any evidence of it at all. Power of disposition of a prohibited act which may or may not have been done by the alleged crew, that is to say, launching the book missile, nor of any acceptance of it. There is no proof. Even if we did suggest that all of our client's own behaviour and the co-defendant's own behaviour, as the prosecution believes it can prove, then, even then, it is quite insufficient to say that our client, despite, and the other co-defendants, despite neither he or any other defendant actually pressed the button, could be considered as functional perpetrators or co-perpetrators in downing an aircraft and committing murder. The actual evidence for this is grossly insufficient, and that is why we invite your court to declare our client innocent of crimes 1 and 2 in the indictment. This brings me now to the participation section, and here I'll be talking about a number of types of involvement: co-perpetratorship, incitement, accessory guilt, and active participation. I'll start off with co-perpetratorship. At a secondary level, our client is being prosecuted as a co-perpetrator of the launch of a book missile using a book tenor near Pervomaisky on the 17th of July 2014, where, together with others, he is said to have caused the downing of an aircraft and to have caused the death of 298 persons. Now, when talking about co-perpetratorship, it is not necessary to prove that all the criminal acts have actually been carried out by the defendant. However, that does not mean to say, conversely, that the defendant's own behaviour is not of any relevance to the question of legal interpretation. His own behaviour is at the centre when talking about co-perpetratorship as well. When talking about criminal responsibility, we're always talking about what the defendant himself did or did not do. Now, you can talk about such a degree of cooperation with other persons that even actions carried out by others may be, to some extent, the responsibility of the defendant. Now, co-perpetratorship, essentially, in de Hulu's words, arises when you have a more or less close-knit cooperation on a reasonably equal footing to carry out the component parts of a criminal act. Here we can see very little debate on this in case law or literature. The limits of co-perpetratorship are debated more often. Regarding its limits, we can see that the behaviour of one co-defendant, one co-perpetrator, and cooperation with the other co-perpetrators must be such that the co-perpetrator shares some responsibility for what the other perpetrators do. The requirements of behaviour and cooperation amount to saying a sufficiently close and conscious cooperation, and the contribution of each co-perpetrator to the crime must be of sufficient weight. The Supreme Court talks about the cooperation in a ruling of 2014, and this is worth looking into. When forming the decision on whether the close and conscious cooperation required for co-perpetration applies here, the court can look into other things, whether the intensity of the cooperation, the division of tasks, the role in preparation, carrying out and wrapping up of the event, and the importance of the defendant's role, his presence at important moments, and whether he did not withdraw at a certain point. Here, in addition, it is worth pointing out that not distancing himself from something does not carry great importance in itself. The important thing is that the suspect must have carried out a major contribution to the crime. End of quote. Now, when you're talking about joint carrying out of a criminal act, you have to accept close and conscious cooperation, and that's normally not a problem. However, when we're not talking about joint perpetration, the evidence often comes into difficulties. The Supreme Court, in the same ruling, spoke about this. The contribution of the co-perpetrator will generally be stated while the crime is committed in the form of joint activity. However, his contribution might have been provided in the form of various activities before and or during and or after the crime itself. It is also not impossible that the contribution largely took place before the crime, particularly in this kind of situation, which is exceptional. evidence must be provided to show whether the cooperation was so close and conscious that co-perpetration arises. In particular, that and why the defendant's contribution was of significant weight. That particularly applies if we are largely talking about behaviours after the crime itself was committed. A small role or an absence of any role in carrying out a crime will, in such exceptional cases, have to be offset, for example, by a larger role in preparing the crime. End of quote. In cases of this kind, which is why compensation is required, it's always important to ask whether, firstly, the cooperation with the others, and secondly, the contribution of the suspect were of such a nature that you could talk about a more or less close cooperation on a reasonably equal footing in carrying out the parts of a criminal act. Prosecution says that our client's contribution and the cooperation with others in this case clearly is such that co-perpetration is of application. The prosecution sees this evidence, which it mentions, by the way, at the same time as functional co-perpetratorship, in the same four circumstances I mentioned before, and these lead to the same prosecution conclusion.
The position of the defense on this is as follows. Regarding the close and intentional collaboration required, this is necessary, as stated, for complicity. Evidence of co-perpetration requires intentional collaboration with the person who perpetrated the offense, or the people who were said to have launched the book missile with the book teller. So the crew, the prosecution has strongly focused on the alleged collaboration between the four defendants, and in some respects even on collaboration between four defendants and the rest of the People's Republics of Donetsk. The prosecution does not consider collaboration between client and those said to have performed the criminal offense. The prosecution argues, we do not know exactly which instructions Gherkin issued in the morning of 17 July 2014. We do not know exactly how communication proceeded between the crew of the tailor and the four defendants, nor do we know what the cause was for firing the missile. In other words, we know nothing about the alleged collaboration between the defendants on the one hand and the crew on the other hand. The prosecution does not even assert that there was a close and intentional collaboration with the crew. To add for the clerk, on the contrary, on page 141 in the prosecution's address, the prosecution asserts that there is no evidence of a subordinate relationship between the defendant and the crew. Now, picking up on paragraph 68, nor can a close and intentional collaboration, even separate from the prosecution, be inferred separately between client and the crew, so separate from the prosecution's address. The only extremely vague circumstance the prosecution mentions concerning an alleged relationship between client and crew is, as Mr. van Eyck argued, entirely untenable and truly baseless. The record does not show that efforts to make calls by client's number to an unknown other number were made by client himself, nor does the record reveal that the unknown number pertained to a crew member, and the prosecution in June 2020 in fact indicated that this has not been proven. Moreover, contrary to what has been argued, if client were assumed to have made unsuccessful attempts to call a crew member, this would merely be an effort to establish contact, no more than that. It cannot even be said to have been an effort at close and intentional collaboration. The purpose of those attempted calls is unknown, nor does it reveal anything about an envisaged collaboration, let alone an intentional collaboration, let alone a close and intentional collaboration concerning launching a book missile. And whatever the purpose may have been of that attempted call, the contact was not established. And aside from aforementioned efforts to make a call, the case file does not reveal the required collaboration or even any contact between client and the alleged crew. Aside from this alleged collaboration, complicity needs to be proven, and it is not. And it is not clear that client contributed to firing as such. So there is no factual involvement proved. No factual involvement has been proven. In 310.3 of the prosecution's address, where those actual acts are discussed, even the section titled "Shooting Down with a Book Tailor" makes no mention of an act relating to firing a missile by client. That section opens by discussing alleged conduct after the missile was said to have been fired. As stated, the contribution required for co-perpetration may not necessarily take place in the course of perpetrating the criminal act. It can, in exceptional cases, take place afterwards. At some point, however, there needs to be a contribution to the criminal act, i.e., contribution to firing a book missile with a book tailor. Answering the question as to whether the alleged contribution of client to firing requires considering his alleged contribution, not the alleged joint contributions by fellow defendants, as the prosecution seems to do in its address by discussing the defendants and their joint contribution to the charges altogether. This is not correct. What matters is the alleged contact of client and whether such is sufficiently essential. The alleged contribution by client, if the prosecution's arguments hold water, would be said to be in the assumptions made, would be reconnaissance, coordinating troop movements, acquiring remits to guard and position the book teller, and the efforts to make calls and the subsequently claimed ownership. If these have been proven, then the following holds true. These acts cannot be seen as carrying sufficient weight toward firing a book missile. So, as for any involvement in firing the missile as such has not been proven in the prosecution's address or the case file, nor has the prosecution stated this explicitly. If the prosecution meant that the acts held against clients, so before and after the launch, if these are to be seen as involvement in firing, then the defense does not accept what the prosecution is stating. That reconnaissance, after all, is said to have taken place at an entirely different moment in early July 2014 and in a different area. They have no relationship with and therefore do not contribute to 17 July 2014. The same holds true for coordinating troop movements. Regarding allegedly expressing the need for air defense, the conversation mentioned in that context took place after the tiller was said to be en route, so disclosing that cannot have influenced the alleged criminal acts. Moreover, if such a remit had been given a client did not carry out this remit, and the efforts to make calls, which have not actually been proven according to the prosecution, such contact was not actually established. And then as for claiming responsibility according to the prosecution, by referring to a conversation about a book tailor as our book, using words such as our, consistently referred to our as in our side of the armed conflict. But how can that be used to infer a sense of ownership of the book? At most, a sense of solidarity with the owner thereof. Referring to a book tailor as our book is moreover not the same as claiming responsibility for firing a book. That is factually simply not the same. The acts charged are therefore not contributions to firing, but at most would be tantamount to knowledge of the presence of a book tailor. So the evidence lacks a conclusive link between knowledge of the presence to a contribution to firing. And that gap in evidence has not been filled, since there is no added value to firing by client. And if the acts in the charges are seen as involvement in firing, then these contributions did not happen while performing the criminal offense, so while firing. And the Supreme Court sets a very high standard to substantiate the question as to why such a contribution is sufficiently important after all. It's impossible to see how what client is doing according to the prosecution could be seen as sufficiently important for firing a book missile, especially if that involvement according to the prosecution is attributed to conversations after the launch, because the Supreme Court states even more firmly that the question as to whether the contribution was sufficiently important must be answered affirmatively. In connection with co-perpetration, the conclusion is therefore that there was no such close and intentional collaboration with the actual perpetrators of the offense, i.e. the charge. And so therefore the actual delinquent act, firing a book missile by the crew, cannot be attributed to client. So client should also be acquitted from the alternative charges. That takes me to other types of participation. Once again, as far as we're concerned, they have not been proven and acquittal should follow, and I refer to what was previously argued in 6.1. This concerns incitement, complicity, and compound participation. In these respects, the prosecution did not address these, and I will make do with the aforementioned reference with a brief reflection on the conclusion mentioned in the previous paragraph, which is that acquittal should follow. Incitement is subject to the following. It is basically deliberately using a means of instigation to have somebody commit a punishable offense. First, the person incited did not want to do it, in any case not definitively, but following the instigation by the person performing the instigation, there were certain means that meant he was willing to do so, and there were 4 means selected: abuse of authority, providing opportunity, means, or intelligence. As for abuse of authority, we refer first of all to the questions above about functional perpetratorship and co-perpetration. The conclusion here is that no relationship, formal or substantive is revealed by the case file. The crew, whoever they may be, has not been traced, identified, or interviewed. Such documents have not been incorporated in the case file. Therefore, no facts or circumstances can or have been mentioned which could reveal abuse of authority. Nor does it appear wise or possible to declare abuse of authority proven based on suspicions, conclusions, opinions, assumptions, and guesses. Lacking proof of instigation of abuse of authority, the charges are left with incitement by providing opportunity, means, or intelligence. The case file does not reveal that client was in contact with the crew at any point or that he provided them with opportunity, means, or intelligence. What client is said to have done according to the prosecution's address does not provide such proof. Nor can it be determined, let alone proven, whether the crew at first did not want or intend to fire, but did so nonetheless because of client's contribution. For lack of information about the crew, we can merely note that we know nothing about what happened in the minds of those said to have been incited. Evidence of incitement or instigation for lack of information on what led the crew to fire will not hold up. It's a sandcastle. Complicity means helping commit a criminal offense. The defendants are charged with having assisted in committing the criminal offense, which the prosecution sees as the defendants having been involved before and during the acts. The alleged opportunity, means, and/or intelligence concern only prior alleged contributions. How this could be simultaneous complicity is not clear in the charge and has not been discussed in the prosecution's address, which is why I'm simply saying that this does not seem to be the case and therefore has not been proven. The alleged contribution of client, according to the charge, is said to consist of active conduct, i.e. deliberately providing opportunity, means, and/or intelligence, and/or deliberately assisting aforementioned alleged acts. Once again, there has been no contribution, nor has such been proven. But if there were a contribution to firing the book missile, whatever that contribution may have been, to prove complicity, some effectiveness of the contribution is necessary. The contribution of the accomplice must have made the basic offense possible or easier, and that is not clear in this case. After all, stating a need for air defense after the air defense, according to the prosecution, was already en route, then by definition does not contribute to the alleged firing. That a suitable firing site was made known to the crew is not clear, not even from a phone call in which a book was said in which it is said that a book can be positioned somewhere near Performaisky. After all, it doesn't say that Performaisky was intended as a suitable firing location, nor does this reveal a relationship between positioning or parking and the alleged firing, let alone it is not clear that the crew was told about this. That the crew was provided with a phone number to communicate effectively has not been revealed. Has not been revealed either that it is, according to the prosecution, it has not been revealed that the phones were provided by or via the defendants, and that the tailor and or the crew was escorted or transported is not a contribution with which client has been directly or indirectly charged, or which he could have made, nor is it clear that effectiveness can be assumed. This is so far removed from the alleged ultimate launching of a book missile that this is not a deliberate effective contribution to the predicate offense, nor is it clear that the contribution client is charged with, which it's not clear that this would have made it possible or easier for the crew to fire a book missile. For lack of knowledge as to who did that for what reason, everything that emerges in the case file is simply a suspicion, conclusion, opinion, assumption, or guess. A criminally relevant contribution has therefore not been revealed in the sense of complicity if there was such a contribution.
Just before the break, it is a somewhat complicated section. I don't know whether you can bear with me. I can continue. I don't know about the interpreters. 3 pages. Yeah. Okay. So this is co-perpetration in participation. So, in conclusion, a position with respect to the co-perpetration of complicity or incitement, the so-called composite participation. Well, I've had to study the charges in order to be able to distill this from it, but theoretically speaking, it is possible. However, it would have to be proven that indeed there is co-perpetration in that sense, in the sense of co-perpetration of participation. And also in this respect, there has to be a close and conscious cooperation and making an essential contribution to the alleged complicity or incitement. Close and conscious cooperation and making an essential contribution to a form of participation of the offences as charged is not does not become apparent in the case file. A close and conscious cooperation. Well, it seems that possibly we would have to look at this. I'm saying possibly because the prosecution does not specify this in its address. Possibly we would have to look at cooperation between our client on the one hand and the fellow defendants on the other hand. The specific behaviors that are being put forward in charges, according to the prosecution, boils down to the following. 1. Gherkin's expressed need for proper anti-aircraft weaponry with a trained crew, the role of Kharchenko in the vanguard of the offensive from Snitnoy, Gherkin and Dubinsky being the commanders of the DPR, also in connection with the supply of heavy military equipment on 15 July from Russia. Dubinsky would have said that Gherkin would pass on the need for anti-aircraft weaponry to Russia, and that he would receive the book, and that Dubinsky, Chernik, Khodorkovsky would arrange for receiving the book. And furthermore, Dubinsky, Gherkin, and Kharchenko would have met in the morning of 17 July 2014, and throughout the day, Dubinsky and Kharchenko would have been in touch with Chernik in connection with further transport of the book. Kharchenko would, I'm saying would, because this does not apply to my client, would do what he was told and would have taken over the escort of the book convoy from Chernik, and would have given Sharpov instructions to guard the book, and would have picked up Gilazov to go to the field. And also the other defendants supposedly referred to the book as their book, and Gherkin would have instructed Dubinsky to make sure that the tailor would leave, and the transport was led by Kharchenko, and Gherkin would act, and Dubinsky would keep close control. Should your court be of the opinion that these behaviors can be considered proven, the defense is not of that opinion, and this applies to everything that we've argued with respect to evidence, but should the court find that these behaviors can be proven, in order to be able to attribute those behaviors to our client, it would require that we establish a close and conscious cooperation in connection with these behaviors, and that has not become apparent. The evidence, as we have argued, is simply not part of the case file, not in connection with the alleged request, not in the form of an alleged hierarchy over Karchenko, because in July 2014 that was not an issue, not at all, not in connection with the transport that was arranged upon instruction or escorted by other defendants, and not with respect to alleged meetings with other defendants, and particularly not points in time that could possibly be relevant because our client was not in charge and simply went in reserve. And for further explanation of our position, should your court find that our client and the fellow defendants did cooperate closely and consciously in connection with the behavior that I just referred to, can that cooperation can still not be considered to be a criminally relevant cooperation in connection with the launch of a book missile on 17 July 2014, because those behaviors do not go beyond the possible transport and presence of a book tailor. Our client and the fellow defendants, possibly in connection with other parts of the war, may have cooperated, but not in connection with these behaviors that are specifically being reproached to the fellow defenders, and not in connection with the book tailor, let alone in connection with the firing of a book tailor on 17 July 2014. There is no close and conscious cooperation between client on the one hand and aforementioned defendants on the other hand in connection with aforementioned behaviors, insofar as they would be connected to the offences as charged. Should that be different? In any case, one cannot prove that client made an essential contribution to the commission of the offences as charged. The factual behavior that our client is being reproached of with respect to the offences as charged boil down to nothing more and nothing less than alleged knowledge of the presence of a tailor. There is no co-perpetration of participation. It does not become apparent. Should that be any different, and should the behavior of the co-defendants be attributed to our client in the sense of co-perpetration of participation, then we would have to assess whether the behavior of our client and the other defendants together could constitute one of the other forms of participation. So we'd have to look at whether that behavior would lead to complicity or incitement. If we look at the behavior that our client and the fellow defendants are reproached of, we cannot say that together they participated in the commission of the offences. I'd like to refer what I already said, because an assessment based on the alleged behavior of the other defendants would not lead to any essential other outcome than what I said with respect to incitement and complicity. Thank you for postponing lunch. Well, it's been quite a long section, not only for the people who are listening, but particularly for the interpreters. So I assume that this afternoon's section, the additional section, you can cover that in one go. Yes, that's short. It's short. It's only 7 pages or so. President of the Court, we will interrupt for lunch. I'm just checking. I suggest that we continue at 2:15. All rise. Please be seated. Court is in session. Ms. Tendoschat, you have the floor. Thank you. Before I proceed with paragraph 117, just a brief comment about what I said before that. When I was speaking, I thought that perhaps I may not have put this as carefully as I intended. Paragraph 80 and 35. And here I say, with respect to contact with the crew, I say that according to the prosecution itself, it doesn't appear that attempts to contact, to make telephone calls have to do with that. In other words, what I realize is that I should take an intermediate step, because the prosecution believes that the DPR providing telephone numbers to the alleged crew does not appear, and the way I see it, that means that you can never say that any attempts to contact that number are attempts to contact the crew. But that requires an intermediate step. I need to add that this is what the prosecution believes, or seems to believe. So that would concern these two paragraphs, in which I believe I should add an intermediate step. Paragraph 35 and 80. And so now I shall continue with my pleading notes. Chapter 4, Intent, starts on page 45, paragraph number 117. All variations as charged of both offense 1 and offense 2 also require, in addition to what I just argued, also require evidence with respect to, at the very least, intent. The intent requirement is, in the case of participation, is considered to be a double requirement. The act of participation have to be intentional, and participation must have had the intent with respect to the predicate offense, the criminal offense in which the defendant would have been involved and or be responsible for. So first and foremost, it has to be about our client's intent, also with respect to the primary charge, the variation in which someone else's actions could also be attributed to our client. In other words, even though actions of another person theoretically can be attributed, the same does not apply to someone else's intent. Someone else's intent cannot be attributed to our client, as stipulated in Dihulu. And I'm quoting when I say, intent cannot be attributed to the functional perpetrator. This is out of the question, because Dutch criminal law does not attribute intent to a natural person if that state of mind, if that person doesn't have that state of mind. Functional perpetrator himself has to have intent if the description of the offense comprises such an subjective element. So, with respect to the evidence, we have to look at whether our client had the intent to, 1, contribute or be responsible for firing the book missile with a book tail out 17 July 2014 near Pervomaisky, or whether our client intended to fire a book missile in order to cause the aircraft to crash or take the lives of those on board. Allow me to first discuss the question regarding intent to participate, and then I will proceed to discuss intent concerning the predicate offense. Participation. As I said, even if somebody himself has not carried out the offences as charged, even then there needs to be intent regarding the act of participation. In other words, acts in connection with the offences charges. The prosecution discusses the matter of intent regarding participation when it addresses the chapter close cooperation in a group of perpetrators. The four perpetrators, and I'm quoting, before 17 July 2014, would have formed a closely cooperating group of perpetrators, and which assertion would be relevant with respect to the evidence of intent. According to the prosecution, the factual behavior of individual defendants must be assessed explicitly in the light of their joint plan to commit offences. In view of their joint plan to use violence against Ukrainian aircraft, according to the prosecution, that would show the joint intent of causing an aircraft to crash. The defense is of the opinion that this review framework is incorrect. With these conclusions, the prosecution is taking all sorts of incomprehensible twists and turns, untenable from a legal point of view. The prosecution seems, without saying so explicitly, but seems, in connection once again with the question regarding intent concerning participation, seems to resort to a sort of combination between one, a close cooperation in connection with other behaviors than those indicted, mainly prior to 17 July 2014, and two, a joint plan of a group of perpetrators to, in general, cause aircraft to crash. This form of close cooperation, as discussed by the prosecution, that, by the way, also seems to concern a cooperation among all DPR forces, which has not been charged, not only the four defendants, and this cooperation, as such, does not play a role in terms of the question whether our client had intent concerning participation in the offences as charged. In other words, whether our client had the intent to carry out behavior that would lead to responsibility for cooperation in connection with inciting and or supplying and contributing to the firing or anything having to do with firing the book tailor with a book missile with a book tailor on 17 July 2014 near Pervomaisky. The prosecution seems to keep referring to this joint plan of this closely cooperating perpetrator group and wrongly is trying to seek support in the notion of intent as in Article 140 Criminal Procedure, participation of an OCG. Article 140 Criminal Procedure has not been charged, so as such, that sort of intent is not part of the trial in suit. Even though Article 140 is not formally an issue, but it cannot be used as a basis by analogy or in a substantive way. Intent is a notion that cannot be interpreted or construed in general terms, but has to be construed in specific terms. The notion of intent of Article 140 Code of Criminal Procedure is interpreted and construed in a way that is incomparable with intent in the context of any other crime, including the crime in suit. Intent in the sense of Article 140 Code of Criminal Procedure is exceptional in the sense that for such a participation, and once again I'm quoting De Hulu, for such a participation it has to be established that the person concerned in general knows, in the sense of unconditional intent, that the purpose of the organization was to commit offenses. We're talking about intent as stipulated in Article 140. So the person concerned need not know of one or several specific crimes envisaged by the organization. So for the specific crime in question, being pursuant to Article 140, this specific form of intent is required. That boils down to knowledge in general is a different form and sort of intent than the intent meant in the charges. For that, intent with respect to the offences as charged, requires intent concerning participation to or in the crime as charged. In other words, intent to contribute to or be responsible for firing a book missile. This is not about intent concerning random behavior on the part of my client, nor is it about intent concerning random behavior of others. At most, it is intent regarding behavior of our client that would have led to a criminally culpable contribution to the predicate offense. And should we assume the client would have acted with the other defendants, not about intent regarding behavior, random behavior of those other people, but specifically the people that he cooperated with, specifically in a way that is related to the execution of the predicate offense. Once again, here it would be intent in connection with the firing of a book missile. Nothing at all in that respect has become apparent. Our clients' behaviors as reproached are not behaviors as such, but would at most boil down to knowledge. If something were to be proven in that respect, it's not a contribution. The same applies to the alleged behavior of the co-perpetrators. These are not actions, furthermore, that are in any way connected to firing a book missile, at most in connection with the moving or the presence of an alleged book. Should one or several of the acts considered to be participation acts, in any case, the case file does not make clear that our client has had the intent to carry out such acts, and this cannot be proven. And now, with respect to intent concerning the predicate offense. Intentional act, in short, is knowingly and deliberately acting. Conditional intent, and I just refer to it as an evidentiary tool, is a minimum thereof and consists of several elements, being the element of knowledge, of risk, and of will. The element of knowledge has to do with the defendant's awareness of the possibility that a certain consequence could take place. Is the possibility or the chance that the foreseen consequence should actually happen, and such a chance or possibility has to be considerable at least, and the will element has to do with the conscious acceptance of such considerable chance. And these elements are summarized by the Supreme Court that there is conditional intent if there's a considerable chance that a certain behavior causes a certain consequence, which consequence is deliberately accepted by the defendant. And for the evidence of intent, the Supreme Court stipulates that the defendant has to have knowingly and deliberately exposed himself to the considerable chance that a consequence will take place. And should that be the case, it is not only required that the defendant knew that the considerable chance would happen, that the consequence would happen, but he also consciously accepted this chance. The simple circumstance that the defendant had this knowledge, or is assumed to have this knowledge, does not mean to say that he consciously accepted this considerable chance, because in the case of this knowledge, there could also be conscious culpability. The person who knows about the considerable chance of a consequence, but who believed that this consequence would not happen, of this person, you could say that he acted very negligently, maybe culpable, but not that his intent was conditionally focused on that consequence. End of quote of the Supreme Court. The premise for the evidence of intent is that all perpetrators or participants must have had the intent regarding the entire crime as described in the charge, and this applies to functional perpetration, but also all the other forms of participation as charged. And this ensues from the requirement for perpetration and forms of execution as such. But in view of the charge in this case, it also ensues from the requirement in procedural law that intent in principle concerns all the elements stated after the word intentionally. For the evidence of each and every variant as charged, intent concerns the predicate offense, and that is that on 17 July, near Pervomaisky, a book missile would have been fired with a book trailer in order to cause an aircraft to crash, causing the death of all those on board. The question to be answered with respect to intent is whether our client consciously accepted the considerable chance that that should happen.
The prosecution uses the term intent in two parts of its presentation, in section 3.10.4.1 on the close-knit criminal group and in section 3.11, conclusion of evidence. I have dealt with section 3.10.4.1 of the prosecution's case in the connection of intent to participate, because it appears that the prosecution is using those deliberations to consider the question of intent to cooperate. In case, however, such considerations might also concern intent to the basic offence, I will now go on as follows. Firstly, the prosecution's point as set out in 3.11. It boils down to saying that intent is not required regarding the civil status of the aircraft or who the individuals on board were. And just because it is possible that the aircraft struck was not the one perhaps intended, that does not mean the case is not proven. That is the prosecution's position. In addition, the prosecution, section 11, addressing the question of intent, still seems to assert that the suspects continued their cooperation by taking care of the tailor even after it was clear that the MH17 had been struck. Now, the defence has the following views on this. Firstly, there is no intent for the basic offence. The prosecution mostly focuses on the consequences of intent or lack of intent of the actual outcome and or cooperation. Prosecution more or less disregards the question of intent of the basic offence, and that is getting ahead of ourselves. Whatever the situation with joint planning and a different intended target may be, there is no evading the fact that you must have evidence of intent to launch a book missile on the 17th of July 2014 with the intent of causing an airline to crash. As I said, the indicted forms of the criminal action and participation, all of them, require intent to commit the basic crime, and in addition they must be prepared for exactly the criminal behaviour, because it is described after intentionally in the indictment. Before we address the question of whether or not there was intent to target a civil aircraft or specific persons, we must therefore consider the question of intention to launch in itself and the reasonably probable result of that. In other words, was there a reasonable chance that an aircraft would crash, and was there a reasonable likelihood that the persons aboard would lose their lives as a result of a missile being launched? And if so, was that reasonable likelihood accepted by our client? And then, if both questions are answered in the affirmative, we can go on to consider whether another outcome was also within the reasonably probable, and what was accepted. The question of intent for the predicate offence can therefore not be disregarded. In order to do that, it is essential for our client to know and wish that a book missile would be launched near Pervomaisky on the 17th of July 2014 in such a way that it was reasonably probable that an aircraft would crash and or that the persons aboard it would lose their lives. There is no sign of our client having any desire for or knowledge of the launch of a book missile. It is not explicitly stated in the prosecution case, and it cannot be derived from the file. Let me explain. Firstly, in addressing the question of whether somebody wanted something, knew something, and consciously accepted the possible ramifications of it, you must first look at what we know about what someone actually thought. In June 2020, the prosecution was still giving the impression that it was open to further information on this subject from the defendants. I quote, the evidence available regarding what the four defendants knew, wished for and did is on file. If the defendants wish to add anything, they still have the opportunity to do so. They are ideally positioned to have access to that information. In March 2020, the prosecution suggested that the position could be stated by, for example, for the defendants themselves to record a video statement by Pulatov. And indeed, our client is exactly the one who knows about what he knew and what he wanted. And he did make that information available in a video statement. Our client is quite clear about what he thought. On the 17th of July 2014, he most certainly did not think or want or wish that a Buk missile would be launched, causing an aircraft to crash and the persons aboard to lose their lives. On the contrary, he thought, as he has consistently said, that there wasn't even a Buk tailor there, not in working order. And if there was a tailor there, he thought it was there for deterrent purposes, as part of a military deception strategy, not in order to actually launch a missile. He did not want, or know, or expect, let alone consciously accept, that on the 17th of July 2014, the consequences set out in the indictment could arise. There's no good reason to doubt what I've just said, and not to believe our client. And I'm not just talking about reasons to question whether or not Buk tailor in working order was present as part of a military deception strategy or not. We discussed that elsewhere earlier. What I want to say at this stage is that there is no good reason to doubt that our client really can have thought and did think, and that he thought that there was no Buk tailor, or at least none in working order. In the earlier part of these pleading notes, it is also discussed that there is nothing on file to prove that our client could not have thought it. If or your court agrees with the defence that there is no reason to doubt our client's position, then there can be no question of intention for the predicate offence. There is no proof of wish or knowledge that a missile would be launched, and a conscious acceptance of the reasonable likelihood of the consequences arising therefrom. And here, there's a appeal court ruling from MLS in 2015, which was maintained by the Supreme Court. The Supreme Court said the court then addressed the statement by the defendant saying that he had no intention, and thought this was not unbelievable, and therefore ruled that at the time of his actions the defendant had not accepted the reasonable likelihood of activity of consequences of his actions. This ruling is enough to acquit it itself, which means the court does not need to consider the other aspects. End of quote. If your court takes a view that there is a reason to doubt our client's statements regarding intent, then we could look at the outward appearances of the actual actions our client is accused of, inasmuch as such things can be proved. From our client's behaviour, however, we still can't conclude that he wanted and knew that on the 17th of July 2014 somebody would launch a Buk missile in order to down an aircraft and or to take the lives of the persons aboard. After all, it's not our client who launched the missile. He wasn't there when somebody else launched the missile. He was not nearby. to any tailor when it happened. He wasn't close to a tailor at any other time. There is no evidence pointing to the possibility of any knowledge or desire or joint plan. The actions of which our clients stand accused, if they can be proved at all, only refer to the position that other people elsewhere allegedly knew a book tailor was there. And that is not even the beginnings of intent to launch a missile. And even if our client, as is not being proved or suggested, even if he was close to a book tailor, even then, his alleged knowledge of the presence of a weapon is insufficient to suggest there was intent to use it. Arendt's essay deals with this question. In questions where a defendant is charged with murder, serious assault, or threat, the suspect often had weapons in his possession, but the simple fact that the suspect had a weapon on him is, according to the rulings, not sufficient to conclude from that the defendant had accepted the reasonable likelihoods of a particular consequence. The threshold, or the outer form of appearances, is generally only reached if the defendant had used the weapon, or at least had it on the ready and was pointing it at the victim, end of quote. The presence of a weapon is therefore not sufficient. If you take the outer form of certain forms of behavior to mean that a specific defendant accepted the reasonable likelihood of specific consequences, then those behaviors of the defendant, or at least the way in which you can derive conclusions from his activities, must go further than simply having a weapon, or at least where knowledge is concerned. The presence of a weapon is insufficient to prove intent to fire it. And this is above all true of a book tailor. After all, as we've shown in section 6.1 of our pleading notes, which I refer you to, a book tailor can also be used as a deterrent, or in order to strike other targets, such as another missile or other projectile. You can't therefore simply assume that a book tailor, if it was there, is going to launch a missile. The problem here is that we don't know why, or who, or where, and at which target a missile may have been launched. We don't know who the crew were. We don't know who sent the crew out to do what, who was giving the orders, what the hierarchy was, whether the crew were given prior instructions, whether they got them on site, who gave the instructions, what the instructions were, which eventually caused the missile to be launched, etc., etc. The prosecution has no answer to any of these questions. The prosecution says the investigation so far has not shed any light on what exactly caused the MH17 to be shot down. We don't know, at this stage, how the crew actually went about it. Our client also hasn't got the answers, and prosecution clearly also doesn't think that our client has the answers or could have them. Prosecution, however, thinks that when it comes to our client's intent, it doesn't matter what the answers to all those questions are. But how can it not matter? It's the very heart of the crimes of which our client stands accused. The who, the why, and the what. And the answers to these questions are very decisive in the question of intent. After all, if the tailor was present with the purpose of using it purely for deterrent purposes, then there was no realistic likelihood that a missile would be launched, let alone that any such missile launch would risk crashing an aircraft and the person aboard losing their lives. If the tailor was there and the crew had been instructed only to launch a book missile in the event of an attack, then there was even less likelihood of the consequences as charged. The likelihood in that case would at most have been that if there was an attack, a missile would be launched to strike an enemy missile which would be present, or some other projectile, or an attacking military aircraft. If there was no attack, and clearly there was none, then there was no likelihood, let alone a reasonable likelihood, that a missile would be launched, with the result that a civil aircraft would crash and the persons aboard would lose their lives. As things currently stand, where we really have no idea whether there was an intention to fire a missile or not, who may have launched the missile, for what reason and on whose orders, and whether there was an error, without knowing all this, we can't simply assume that our client accepted a realistic probability that a missile would be launched which would cause an aircraft to crash and the persons aboard to lose their lives. The prosecution refers to the alleged continued cooperation after the MH17 crashed, and that changes nothing. Well, in theory it is possible that the continued cooperation was relevant in the question of intent to the predicate offence. There's a court ruling of 1993 which deemed intent to be proved, although the actual predicate offence went further than was intended, because the cooperation with a co-perpetrator continued even though the defendant was aware of the great likelihood of a shooting with lethal consequences, because the defendant was there at the time that the crime was committed and saw that the co-perpetrator was pointing a weapon at the victim. There's nothing like that in this case. No one is suggesting, at any rate, the prosecution aren't suggesting, that the client was present when a book missile was launched, that he was aware of it and therefore he saw it happening. Now, since our client was not there and he knew nothing about the fact a book missile had been launched, and no kind of intent to the predicate offence can be deduced from his cooperation with co-defendants regarding transporting a book tailor. In addition, the case law on this subject says that continued cooperation is relevant when it is the criminal participant. That is to say, that would be cooperation with the crew of the tailor. This has not been proved and is not asserted. Prosecution says there was continued cooperation between the four defendants. Briefly, neither the file nor the alleged knowledge that the book tailor was present, nor the cooperation with the co-defendants can lead us to the straightforward conclusion that our client accepted the reasonable likelihood that an aircraft would crash and the persons aboard would lose their lives as a result of a book missile being launched. The question of the absence of any intent to target a civil aircraft MH17 prevents the case being proven, and need therefore not even be asked, because intent to the predicate offence can absolutely not be proved.
Should your court disagree with that, then, contrary to what has been argued, the question I just mentioned will alternatively be relevant, and that, as far as the defense is concerned, would prevent the declaring the charges proven that there was no intent to hit the MH17 and kill those on board. The prosecution believes otherwise and asserts that it doesn't matter for the question of intent who or what was hit, that a plan to fire in general, it should be sufficient to prove intent. Whoever uses others, and the prosecution believes to mean the crew here by others, who uses others to carry out his criminal acts, incurs the risk while things may have taken a different course, you're still responsible. And the position of the prosecution is that whoever has others do their dirty work should be liable for that. That's in a footnote to the prosecution's address. The author being quoted in that context by the prosecution qualifies this statement as going out on a limb himself, and this is understandable because it is going out on a limb. That same author then qualifies this by quoting Dahulu, who argues that intent may extend to certain circumstances resulting from events set in motion by others. Not every action can be entirely controlled, and then a slightly different course of events may still qualify as being accepted, a somewhat different outcome and course of events of the main offense than the participant envisaged are inherent. Postma considers comparably that the intent requires the intent of the participant extending to components brought about in the description of the criminal offense, and B, how those components are performed. In other words, intent to cause an aircraft to crash and taking into account that the lives of those on board would be taken so that those on board would be killed is required, but may under circumstances be the case that a slightly different course of events is within the scope of intent of the non-executive defendant. Even if it is divergent or extends beyond what was envisaged, even then, the intent of the participants in any case requires a common essence. In that way, the intent requirement contains the liability of the participants and hold them liable only for the part of the predicate offense covered by their intent. Ranches, in connection with the question about intent of a co-perpetrator, Ranches has argued that to avert the undesired situation in which the co-perpetrator is held fully liable for violence, as well as for the likelihood that there was no indication in advance, there should also be a containment in the requirement that the qualifying violence of the co-perpetrator must have been foreseeable. Hitting a civilian aircraft such as MH17 and taking the lives of those on board was not foreseeable. It was not part of a joint plan, and it does not concern the joint essence of what client and the co-perpetrators that the prosecution argues he worked together with would have known or wanted. On the contrary, client made clear that he did not know and did not want a book tailor to fire a book missile which would cause the airplane to crash and take the lives of those on board. The considerable likelihood that the MH17 would crash and those on board would be killed is not contained in such intent, not even if such intent means that there was a plan to hit Ukrainian aircraft. If the case file were to reveal that client had such a plan, then the crash of MH17 is not a slightly different course of events. It's not a somewhat different outcome and content of the predicate offense that client is said to have envisaged. The MH17 crashing and those on board being killed is not just a bit different from hitting a Sushka. It's entirely different. It's something that nobody took into account. Nobody was aware of it, and nobody accepted it. Given facts and circumstances that the prosecution appears to be the case, that was certainly not applicable. After all, the prosecution believes that the missile was fired by a teller with a professional crew. In a teller, a professional crew has enough sophisticated instruments to determine the target. Based on the IFF proceedings, it may be determined whether the potential target is a friend such as the MH17 or a foe such as a Sushka. Moreover, various features are perceptible based on which a civilian scheduled flight may be distinguished from a fighter jet or other military aircraft. Trained crew may and should be expected to be able to distinguish between the MH17 and a target. This does not mean that things cannot nonetheless go wrong, but it does mean that it cannot be expected or foreseen, let alone that it will go wrong. The likelihood is particularly small, so not substantial, and nobody was aware of this, so therefore nobody accepted that likelihood. It therefore cannot qualify as a certain risk that should be accepted. In other words, there was no intent for the consequences of causing the MH17 crash and those on board to be killed, even assuming that the likelihood of firing a missile could have considered that. So the conclusion is that conclusive evidence of the predicate offense, because the considerably likelihood that a plane would crash and or those on board would be killed by a book missile fired by a bookteller on 17 July 2014 has not been accepted, let alone there a considerable likelihood that MH17 would crash or those on board would be killed. So the consequences have not been accepted. Finally, about premeditation, that's my last topic. To prove murder, as has consistently been charged as offense 2, in addition to conditional intent, evidence of premeditation is required. In the legislative history, premeditation is a point of calm consultation and deliberation, the contrary of a sudden heat of passion. The Supreme Court sets high standards for proof of premeditation. The defendant must have been able to take some time to deliberate or take the decision concerned, so that he did not act in the heat of passion, so that he had the opportunity to consider the significance and consequences of the intended act and to take account of this. It may be difficult to prove, but what matters is that the defendant must have truly contemplated and taken into account the consequences and then have acted. Until the prosecution's address, we were very curious what the prosecution would see as premeditation. It seems to be so very remote from the situation that even the main scenario concerns a situation in which nobody believes that the MH17 was hit intentionally. It is therefore difficult to see how premeditation could apply. As stated, we were very curious, and we still are. The prosecution in its address does not answer how or why there was premeditation. Premeditation is mentioned only once, I quote, "Defendants therefore jointly intended to cause an aircraft to crash," and because an aircraft always has one or more people on board, defendants also had the joint intent, and this is about premeditation, and given their deliberate action, therefore premeditated killing those on board the aircraft. This does not take us any further than that the prosecution attributes premeditation to deliberate action. Which plan was there? The plan to hit other Ukrainian military aircraft at other moments with different weapons by other people? That plan is not clear in the case file, but is presumed by the prosecution to exist because apparently at other moments, other people using other weapons apparently caused other military aircraft to crash. Should that prove it? How could this constitute evidence of premeditation to prove the assertion that client premeditated causing the crash of the MH17 and taking the lives of those on board? We can't answer this question, and it should not need to come from us either. We can note counterindications. Counterindications are that client specifically did not want there to be a book tailor. He did not want a book missile to be fired, and he certainly did not want the MH17 to crash, and he certainly did not want those on board to be killed. Another counterindication to premeditation is that nobody intended for the MH17 to be hit. Client did not, nor, as the prosecution explicitly assumes, did the crew. The prosecution assumes an error. Errors are possible. If they are the case, may or may not constitute criminal culpability. The question about guilt is the first question that otherwise, how premeditation could apply in such cases is hardly conceivable, and it has certainly not been proven conclusively. The conclusion in connection with this entire section is as follows. The prosecution drafted charges creatively in an effort to hold persons who did not press the button or instruct that to hold them criminally liable for causing the crash of the MH17 and or taking the lives of those on board. This effort fails. Client, both legally and based on common sense, is not one of the people responsible for this tragedy. And to avert that such persons being drawn within the confines of what can be held criminally liable with it via obscure structures, the confines of functional perpetratorship should not be overlooked. According to Noyon, Langemeyer, Remlink, and others, it needs to be averted that via the functional path, people are identified as perpetrators who are not, in fact, and are qualified as participants, and that those qualified participants might go with impunity. None of the types of perpetratorship or participation charged can be proven convincingly. The requirements necessary for the evidence have not been met, nor can intent or such participation in the predicate offense be proven. If the above, including intent to commit the predicate offense, has been proven, then the MH17 and those on board are not subject to intent, because that likelihood was not substantial, that cannot be accepted. There was no premeditation of firing a book missile and causing an aircraft to crash, taking the lives of those on board. That did not apply. If your court, unfortunately, contrary to what we have explicitly substantiated, believes that one or more of the factual charges can be proven, these acts do not contribute to the criminally liable contributions. So we request that your court acquit client integrally. I have another small part, I believe only 5 pages.
There are a number of topics that we have not yet addressed in oral arguments. This concerns the question regarding combatant immunity, the law that is applicable on this case, claims of the injured party, the relatives, length of the sentence and arrest warrant. I shall briefly discuss these topics, and on Wednesday we will proceed to our concluding remarks. First, combatant immunity and applicable law. The prosecution discussed the question regarding combatant immunity and applicable law, but did so in a way that wasn't entirely comprehensible. The public prosecution overlooked the question whether the armed conflict can be construed as a non-international armed conflict or an international armed conflict. This is incorrect, both with respect to the question of combatant immunity, but also the question of the law that is applicable. If the conflict can be construed as an IAC, internal armed conflict, there are other rules that apply than if the conflict is earmarked as an IAC. In the case of IAC, the review framework with which the public prosecution's right to institute proceedings and the assessment thereof should start, then the situation concerning combatant immunity is quite different than in the case of an IAC. And also, prosecution based on national general law, respectively humanitarian law of war, can be more imperative in the case of IAC as opposed to an IAC. Prosecution's decision to prosecute on the basis of Dutch general criminal law and the position of prosecution that combatant immunity cannot be at issue here seem, at the very least, to be questionable, or perhaps even too questionable, in the case of an internal armed conflict. And that would mean that the prosecution implicitly assumes that this is an IAC, a non-internal armed conflict, which seems to be at odds with the stance the prosecution seems to take in the case reflected in the interstate complaint against the Russian Federation. The prosecution has, in order not to obstruct either procedure, both the criminal case and the interstate complaint, and also in view of these conflicting positions. In any case, the prosecution refrained from specifying whether this is an IAC or an IAC. But the prosecution did take a substantiated view with respect to the question as to whether or not there can be combatant immunity and the choice in favor of applicable law. The prosecution, quite apart from the matter of impartiality, this matter that your court should look into, but in any case, the prosecution has obligated your court to respond to this matter. And by extension, we expect that the questions regarding combatant immunity and applicable law will somehow be reviewed by your court, which is the reason why we wanted to briefly touch upon the matter. We did not forget about the matter, but the reason we shall not discuss the details of this issue, and this is also the reason why prior to the defense on evidence, we did not discuss the matter. That is due to the fact that in connection, we are not putting forward an actual genuine defense. Pulatov has decided not to actively claim combatant immunity or the question which law is or is not applicable. So he has decided not to put forward defenses that could lead to an inadmissibility. As far as the first point is concerned, which is combatant immunity, he does not want to hide and shall not hide behind the immunity of the Russian Federation because he simply doesn't agree with that. He has pointed out before why he was in eastern Ukraine, which was neither on behalf nor upon instruction of the Russian Federation. And as far as the second point is concerned, a question of applicable law, he does not want to, nor shall he, hide behind the legal limits of an armed conflict because he is absolutely certain that he has nothing whatsoever to do with the offences as charged. He does not wish to invoke these formalities. He sees it as formalities that could lead to an end of this case without a substantive judgment of the offences. He simply does not want to invoke that. He wants the offences and the facts to be investigated and to be assessed in the context of a fair trial pursuant to Article 6 the ECHR. And that is the reason why combatant immunity and applicable law was not discussed when we discussed the prosecution's entitlement to prosecute. And now, the claims, the relatives, the length of the sentence, and the arrest warrant. Should your court acquit our client, the length of the sentence will not be an issue, and the demands of the prosecution should be declared inadmissible. We are absolutely convinced that a conviction is not a legally correct possibility, which is also the reason why we will not discuss the demands for sentencing, nor the claims. We will suffice by making just a short remark in addition to what we have said with respect to the demand for sentencing, which boils down to that the demands for sentencing are inadmissible because an assessment would require expertise with the Ukrainian civil law, which is something we lack as parties to the proceedings. And our explanations and comments on this, we request them to be considered to be incorporated in these pleading notes. In addition to that, we would like to highlight the following. If your court considers the demands of the prosecution to be admissible, should your court unexpectedly proceed to a conviction and hence assume that our client in a couple of telephone conversations heard that others were dealing with the transport of a book tailor, then those facts can really not justify a lifelong imprisonment. He cannot be the person who has to spend the rest of his life in prison. He is not personally the person who would have to assume all that responsibility and all those claims. Please don't misunderstand us. No sentence is high enough with respect to the unspeakable gravity of the implications. But in this case, it's a matter of barking up the wrong tree. And by extension, we are, to be complete, would request, should a conviction follow, unexpectedly, to dismiss the demand that our client be arrested. That's it for today. Thank you. Well, that means, says the President of the Court, that this is the end of today's hearing. And we shall continue Wednesday afternoon. And that you will put forward your conclusions. So we're suspending the hearing until Wednesday afternoon, 1 p.m.